Is the city ready? Are you guys ready to proceed? Oh. Are you ready?
30 seconds, please. 30 seconds.
All right, I hereby call this meeting to order. This is the special magistrate meeting for the city of West Palm Beach. I want to begin by explaining how this process is going to work. I will hear the building cases on the agenda first, and the city will call the cases as they appear on the agenda. If you've appeared at today's hearing, your case will be called before those cases where no one has appeared. That's only true if you have signed in. Please make sure that you check with an officer in the back of the room to make sure that you have signed in appropriately. Once your case is called, I ask that you come down to the podium on my right-hand side, which is right over there. The city will put on its testimony and evidence first. You'll have an opportunity to review the evidence and ask questions of the city's witnesses. You'll also have an opportunity to testify and present me with your own evidence. Once I have all the testimony and evidence, I will make a ruling. I will also enter a written order either today at the hearing or in the next few days, which you'll receive a copy of. If you have any questions as we go through the process, please feel free to ask them. This is not a formal courtroom. The formal rules of evidence do not apply here. Now, although this is not a formal courtroom, all testimony today is given under oath. So if you're going to testify, or you think you might testify, or there's a possibility that you might testify, please stand and raise your right hand, and I will swear you in. Do you swear or affirm the testimony you're about to give will be truthful and accurate under the penalty of perjury under the laws of the state of Florida? Yes, sir. Please be seated. City can call their first case.
First case number 1118 23rd Street, CE 230400095, number 1.
Good morning. My name is Ryan Brown. I'm the Chief Plumbing Inspector, City of West Palm Beach. Code case is CE 23040095. Address is 1118 23rd Street. The violation that I saw that day is an unsafe, unsanitary condition per 116.1 of the West Palm Beach Amendments. Potable water is required for sanitary conditions in a property. I issued a violation and posted the stop work order red tag on the job on the property on 4/10/23. The notice of violation was mailed via certified mail and regular mail, both on 5/2/23. It was posted at City Hall on 5/2/23. Was posted on the property on 5/4/23. The certified mail was delivered to what was written down as front desk on 5/6/23. I personally witnessed and took pictures of the missing water meter, showing that there is no potable water to that property. A meter and an active water account is required for potable water. So they will need to secure a water account and have a water meter installed by utilities. I do have a copy of the notice of violation and an affidavit of posting in my folder. And the city recommends $30 or 30 days or $50 a day after that. I'm pretty sure that's a reasonable amount of time.
Thank you very much. The photographs that we've been reviewing during your testimony, do they truthfully and accurately depict and represent the alleged violation that you've observed?
They do.
And I know you said that this is a reasonable amount of time. Has there been any communication from anybody representing the respondent or the owner?
Yes, actually, the owner himself put in a request to the mayor's web key, the new system, for us to go site the property, as he felt like it would help him remove the tenants that are dwelling in occupying the property outside of the agreement, and he thought that it would help him. I tried to explain that wasn't really, we don't evict people, but nonetheless, once I'm aware of a violation, that I have to cite it, and so now he's stuck with the violation, unfortunately.
Okay, thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, stop work order or red tag, and any and all other documents relied upon.
Without objection, so admitted.
I'm sorry?
I was just admitting the documents. Does the city have any further questions?
No, sir.
What was the recommendation?
30 days or $50 a day.
Sorry, I've had a hard time hearing you. So you said you did speak with the owner?
Mm-hmm. Yeah, I spoke with him a couple of times. He's called me several times. He thinks that I can get the people out of the property. That's not what we do. He needs to take them through the police department and eviction court, not us. I've spoken to him several times. He now understands that it is either his responsibility or the tenant's responsibility to put a water meter in on that property.
Any reason to believe that this couldn't be done within 30 days?
It can certainly be done.
All right, in case CE 230400095, I make the following findings of fact and law. I find notice is sufficient to find the property in violation of Code Section 116. Specifically, there is unsafe and unsanitary conditions, that there is no potable water on the property. I give the respondent 30 days to bring the property into compliance, or fine of up to $50 per day, Mason.
Thank you.
Case number 246618, Lytle Court, CE 220400235, number 24.
Good morning. Inspector Attilio Bilal for the City of West Palm Beach. This code case is CE 22040235 for 6618 Lytle Court. The violation I observed was a shed, a residential remodel, a driveway, and plumbing installed without proper permits or inspections. I issued the violation and posted the stop work order on 4/9/22. The notice of violation was mailed on 5/3/23 and was posted at City Hall on 5/3/23. Was posted on the property of 5/3/23. The certified mail was delivered on 5/6/23. While I was investigating some expired permits status, I found that the work proceeded. All permits have been obtained and passed inspections for all the violations except for the shed. The shed has an applied permit of 22060388. Permit and inspections are required for the work I observed. Permits have been obtained. Permits have been issued, except for the shed permit. Inspections have been performed for the previous work, which was the residential remodel, the driveway, electrical, and the plumbing. Included in my file is a notice of violation and affidavit of posting. I have had contact with the owner, but not recently. The owner stated that he's going to address the failed plan review comments and address the shed permit and get it taken care of as soon as possible. The city recommends 180 days to comply and $25 a day after that.
Thank you very much. Just a couple of housekeeping questions. Does the affidavit of posting reflect that the notice of violation was also sent by regular first-class mail?
Yes,
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations you observed at the property?
yes, they do.
Just to make the record clear, the shed is the only issue outstanding. Is that accurate?
That's accurate.
And this is a shed that was installed, or was it converted, or?
It was a newly shed that was installed. The owner of the property was unaware that the shed installer did not obtain the permit. There it is right there in that picture. The owner did not realize that the contractor that installed the shed did not obtain the required permit.
Okay, just for the record, you've given them you're asking for 180 days. Do you believe that's a reasonable amount of time within which to bring this alleged violation into compliance? You said it has failed failed plan review, and they're addressing the comments. 180 days is a reasonable amount of time?
Yes, it is.
Okay, thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, stop work order or red tag, permits alluded to, as well as any particular comments documented, and any and all other documents relied upon.
Is that objection so admitted? So you asked for 180 days, or how much?
180 days or $25 a day.
Is that a sufficient amount of time to get all these permits?
Yes, it's just one permit for the shed. They've obtained all the rest.
Which permit is still outstanding?
The shed.
So you're still proceeding under all of these sections?
The, let me see here.
So
The 105.1 would stay, the 109.4 would stay, the 110.3 would stay, and, let me see here. Plans required. They have submitted plans for, so the 107.1 could be eliminated.
So they just have to secure the building permit
And inspections.
and inspections. Okay. And they performed work prior to obtaining the inspection. Is that correct?
Say that again?
They performed work before obtaining the inspection.
Yes.
All right, in case CE 22040235, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 105.1, 109.3, and 110.3, specifically the building of a shed without attaining the proper permits, inspections, and commencing work before the permit was issued. Hereby order them to come into compliance within 180 days by obtaining a building permit and required inspections, or a fine of $25 per day may issue.
Number 25, 419 45th Street, CE 22040340, number 25.
Inspector Attilio Bilal for the City of West Palm Beach. Code case CE 22040340 for 419 45th Street. Violation observed was a metal building Quonset hut installed without the permit or inspections. I issued a notice of violation and posted a stop work order on the job on 4/21 of 22. The notice of violation was mailed via certified mail and regular mail on 5/3 of 23. Was posted at City Hall on 5/3/23 and was posted on the property on 5/3 of 23. The certified mail was delivered on 5/8 of '23. While performing an expired permit status check, I found that the steel building Quonset hut was actually installed without the benefit of the permits or inspections. Permit number 17020296 was applied for but not issued and has failed the plan review comments that needs to be addressed. Pictures being shown truthfully and accurately depict the alleged violation and reflect what I am testifying to. Permits and inspections are required for the work I observed. For the pictures that are shown, permits have not been obtained. They have been applied for. Inspections have not been performed. Included in my file is a notice of violation and affidavit of posting. I have made contact finally with the property owner. The property owner is going to address the failed plan review comments, get the permit and inspections as requested, and the city recommends 180 days and $25 a day after that. I believe that the time for the alleged violation is a reasonable amount of time to gain compliance.
Thank you very much. I don't have any further questions. The city submits as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, stop work order, red tag photographs, the permit alluded to, the plan comments, or the plan review comments, and any and all other documents relied upon.
Without objection, I'll accept those documents and evidence. In case CE 2204034, I make the following findings of fact and law. I find notice is sufficient to find the property in violation of 105.1, 109.4, 110.3, and 107.1, specifically the building of the outside structure. Is it an awning? Is that what it is?
No, it's a steel building, Quonset hut.
Okay.
They look like a bunker. They're domed.
Yeah, it's hard to tell from the top.
Yeah. The homeowner just came in yesterday and reactivate the permit, and they are diligently working on trying to obtain it and move forward with it.
And specifically building that metal building without a permit, respondent has 180 days to bring the property in compliance or a fine of $25 per day may issue.
Number 26, 1438 North Mangonia Circle, CE 220600179, number 26.
Inspector Atilio Belisle for the City of West Palm Beach. Code enforcement case CE 22060179. The address where the violation occurred was 1438 North Mangonia Circle. The violation I observed was a shed, irrigation, mini split AC system, electrical, a wooden deck, a driveway was installed without permits or inspections. I issued the notice of violation, I issued the stop work order on the job on 6/14 of 22. The notice of violation was mailed via certified mail and regular mail on 5/3 of 23, posted at City Hall on 5/3 of 23, posted at the property on 5/3 of 23. The certified mail was delivered on 5/11 of 23. The observation I observed was I received a phone call from Code Enforcement Sergeant Heiser requesting our department perform a site visit with him at the property with the owner to explain to the homeowner that permits are required for the work that was performed. When performing a site visit, found that the owner of the property was operating a rooming house with unaffiliated individuals and multiple divided rooms within the home, and separate entrances were added to the home, and sheds were installed where individuals were living outside in the shed, and the property owner had installed a new shed and was informing me that he intended on renting it out as well to individuals on the property. The property owner did not have a rental license for this type of rooming house being occupied. After the sheds were installed, the property owner removed the sheds. He's complied by removing all the violations except for the interior bathrooms that were constructed for the individual rooms. The property owner admitted that his intent was to rent out the rooms individually to individuals in the property. The property has several entrances that they've installed. They need to get permits for the demolition. Permit number has been applied for, 22120031. Get the required inspections for the demolished bathrooms that were installed to gain compliance. They did obtain permits for the irrigation, 22070372. The driveway that was extended to allow for additional occupants of the property has now been removed and sodded and back to its original state. The property owner communicated with me. They're out of the country right now in Guatemala, and they were going to try to be present at this hearing, but unfortunately it doesn't appear that nobody's arrived. The city's requesting, the city is requesting 180 days and $150 a day after that to bring the alleged violations into compliance. And I believe that's a reasonable amount of time to gain compliance.
Thank you. Just a couple of questions. Is there an executed affidavit of posting in your file?
Yes.
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, they do.
I listened intently, and I wonder if I missed. You talked about the shed. What about the irrigation? Still outstanding?
No, they obtained all their permits and removed all the violations. The items that were installed without permits have now been removed, and the only thing that's outstanding is they need to get a demolition permit for the bathrooms that were installed without permits.
I just want to be very clear, just for the record, because it's here in the agenda. Electrical,
Yes, that is no longer, they removed all the electrical.
the mini split.
Removed.
Very good, thank you. Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, stop work order or red tag, photographs, permits, and plan review comments, and any and all other documents relied upon.
Without objection, I'll accept those in evidence. All right, so just so I understand correctly, so they put all this stuff out there, including the driveway and these sheds, but they've removed all that.
Yes.
So the only thing outstanding at this point is that the bathrooms, are the bathrooms still there?
Yes, there was 2 bathrooms that were constructed inside the home for an additional occupants, and in order to gain compliance, they need to get the permits necessary to properly demolish the bathrooms, cap them off, and make sure that they're no longer going to be separate rooms with bathrooms inside the home.
So they either need to permit the bathrooms or demolish them, I guess.
There's
There's no way to permit them?
no way to permit them.
So they have to be demolished? Okay. And that's it? That's all we're talking about is these
Yes.
bathrooms? All right. And 180 days, I think you already testified that 180
Yes.
days is sufficient amount of time to do this?
Mm-hmm.
Yeah, okay. All right, case CE 22060179, to make the following findings of fact and law. I find notice is sufficient to find the property in violation of the listed code sections, specifically the building of these bathrooms without proper permits. I give the respondent 180 days to obtain a demolition permit and remove these bathrooms, or a fine of up to $150 per day may issue.
Number 27-1204 Worthington Street, CE 22080229, number 27.
Inspector Otilio Belisle for the City of West Palm Beach. Code enforcement case CE 22080229. The address where the violation occurred is 1204 Worthington Street. The violation I observed was in exterior laundry rooms that were installed for the residents. Building, plumbing, electrical installed without permits or inspections. I issued a violation and posted a stop work order on the job on 8/6/22. Notice of violation was mailed via certified mail and regular mail on 5/3/23, posted at City Hall on 5/3/23, and was posted at the property on 5/3/23. The certified mail was delivered on 5/6/23. While performing routine daily inspections, I noticed that 2 structures were constructed on the exterior of these rental properties that included laundry rooms, building, electrical, and plumbing. While checking the system, I found that no permits were obtained for these structures. The pictures being shown truthfully and accurately depict the alleged violation and reflect what I'm testifying to. Permits and inspections are required for the work that being observed and displayed in the pictures shown. Permits have not been applied for. Permits have not been issued. Inspections have not been performed. Included in my file is a copy of the notice of violation and affidavit of posting. I have not had any contact with the owner or contractor. The city recommends 180 days to comply, or $25 a day after that. The time to bring this alleged violation into compliance is a reasonable amount of time.
Thank you. I apologize. I had administrative issue behind me. Just to clearly make sure, because I know I missed a lot of that, and I do apologize. Again, certified, regular posting of the property, posting to City Hall done?
Yes.
Executed affidavit of posting in your file?
Yes.
Photographs truthfully and accurately depict and represent
Yes.
the alleged violations that you observed. And you were asking for how much time? I do apologize.
180 days and $25 a day after that.
You feel that's reasonable?
Yes.
Very good. And stop work order as well was done?
Yes.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, stop work order, or red tag, any permits, plan review comments, and any and all the documents relied upon.
Without objection, so admitted. So this is outside structures and a washing machine, is that it?
Yeah, they constructed laundry rooms on the exterior of the home on two separate structures. If you can see here in the pictures, they constructed these to include washers and dryers with plumbing, electrical, and building. You can see there.
It's like an awning thing, is that it?
Shed, awning, building, laundry room.
It's a structure that requires a permit.
Yes.
Okay. All right, and you said you had no contact with
No.
Okay.
I've stopped at numerous occasions and talked with the tenants that live in the property, and I requested that the property owner contact me, and I've yet to receive any contact. I've left my card on numerous occasions and spoken with the tenants.
So this is a rental property, and these facilities were made for the renters, I guess, is that it?
Yes.
Yeah. So these can be permitted, they just haven't applied for any?
I don't believe that they can be permitted due to the fact that they are right on the property line and the way that they're constructed.
Fair enough. In case CE 220802229, I make the following findings of fact and law. If I notice is sufficient to find the property in violation of 105.1, 109.4, and 110.3 specifically, building outside structures without a permit, I order the respondent to come into compliance within 180 days or a fine of $125 per day may issue.
The fine was 25?
No,
125?
How much did you ask for?
hang on one second. 180 days to comply, $25 a day after that.
Okay, that's what I ordered.
Next case number 6, 519 Clematis Street, CE 230400109. And we do have someone signed in for the case that will need to be sworn in. Come to this microphone here.
If you've come late and you haven't been sworn in, please raise your right hand. If you're going to testify at all, do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury and the laws of the state of Florida? Yes. Go ahead.
Chris Jackson, City of West Palm Beach, Environmental Compliance Specialist, Stormwater. Here today, I was brought to notice that 519 Clematis had a illicit discharge in the alley behind the restaurant. Went and did some investigation and found out that there was a illicit discharge into the storm drain that sits on the east corner into the alleyway. Notified at that time there was construction at the site. Notified the manager that thought that was on duty. Name was Leah Escobar. Talked to her. I notified her and let her know that there was a illicit discharge and that they're given the opportunity to clean it up themselves, or we, the city, would clean it up and fine and fees for labor costs. And I was given the go ahead and do so.
Thank you. Officer Jackson, just a couple of questions. Was there a notice of violation generated in this case?
Yes.
Do you have that date of the notice?
5/4/2023. 4/4/2003.
I'm sorry, of 2023?
Yes,
And was that notice sent by certified mail?
correct.
Was that notice sent by regular mail?
Yes,
And was that notice, the address used, was that done by using the address that was listed in the tax appraiser's office or the property appraiser's office?
correct.
Okay. And was the notice posted at the property?
Yes,
Was the notice posted at City Hall?
yes,
Is there an executed affidavit of posting in your file?
yes,
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violation that you've observed?
yes.
And what kind of a remedy are you seeking? A fine? What are you seeking?
The city, we're asking for $1,000 fine and labor costs that we recoup for cleaning up.
And I'm sorry, say it again, I missed the last part.
$826 for the labor costs the city used to clean up the property.
Okay. And other than the communication that you mentioned with, I can't remember the name of the person that you talked to at the time.
Leah Escobar.
And then is it my understanding that you were approached by the respondents that are standing here this
Correct.
morning? You talked to them, and what was the substance of that conversation?
The conversation back, they had no knowledge of what was going on until they saw the notice of posting. But this was my first time contact of
Okay.
speaking to them since.
Okay. Mr. Frasca, did you have something you wanted to testify to? Mr. Frasca?
John.
I just wanted to state that the invoice for the city charges are included in the case.
Okay, thank you very much. I appreciate it. And are you asking for the $1,000 to be irreparable or irreversible? In other words, is it your testimony that the illicit discharge cannot be undone?
Correct.
It can't be reversed. Is that
Correct.
accurate? And what is it about the illicit discharge, or what is it about what you saw that made you believe it was an illicit discharge?
So the illicit discharge was oil and grease, which is the Stormwater Code -9203A. There's no illicit discharges that goes into the city storm systems at all. So there's videos of the oil and grease on the ground and as well in the storm system.
Okay. And is there something about what it is you saw that made you think it was oil and grease versus just dirty groundwater?
There's the sheen that tells right there in that picture there. The oil and grease composites mixed together when oil and water mixed together. And then there was the cleaners that was there from 5 o'clock that morning cleaning the back area of the restaurant.
Okay. And so you're asking to recuperate the $826 in labor costs
Correct.
as a part of the cost to recover in this particular case?
Yes.
As a part of this case?
Yes.
Okay. And then the $1,000 irreparable or irreversible fine, correct?
Yes.
Okay. Thank you, Special Magistrate. The city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, invoices, any and all other documents relied upon.
Sorry, can you tell me your names, please?
Chris Papandrea.
I'm sorry, Chris
Papandrea.
Papandrea?
Papandrea.
Papandrea. Ma'am?
Rainy Coon.
One more time?
Rainy, like the weather.
Okay.
Rayne, and then Coon, Coon.
Rain Kuhn. And what is your position with the, I guess the owner of 517 Clematis Realty?
I am the Director of Operations for the Kapow Group.
You're the director of...
519. The 519 where the violation was.
Okay, so you're the director of operations of 517 Clematis Realty?
519.
Five.
519 where the violation
519,
was.
okay. So I have the address at 519, but I have the owner at 517.
I think 517 is the actual billing address for the property from the Sunbiz information that I have.
Okay. All right, do either of you have any objections to the city putting to evidence their photos and documents?
No.
That objection, I'll admit that into evidence as city's composite exhibit 1. Is there anything further from the city?
No.
No.
All right, so what's going on?
So I think, I mean, obviously I think it's mostly like a perception thing. I was telling him out there that the mats that they're washing in the back there that he or saw them washing, those are not mats that are in the back of the house per se. Like they're actually our bar mats. So there's no food, no grease, no oil that's really getting on those mats because we don't have that behind the bar. We don't have any kind of rubber mats like that in the back of the house where oil and grease and stuff would be spilling all over that. We have let our cleaning crew know that they need to rinse those mats, even if there are bar mats.
Let me ask you, so the city's alleging here that cooking oil was put in the storm drain. I guess that's the big issue here. Are you saying that that's not the case?
Well, I mean, in that picture that he showed us that there were pots out back, which aren't really a normal thing for us, so I'm not really sure. I'm gonna have to investigate that on my end to find out why there were pots. I don't know what was in those pots. They very well could have been, at that time, grease or oil. I'm not denying that. I don't know. I wasn't there. So we're gonna have to further look into that on our end, because that's not a normal thing for us. But as far as the bar mats go, I'm very confident that when they're rinsing those bar mats off, there's really no oil or grease coming off of those. But how is somebody supposed to know that coming off the street, not knowing that what's in our restaurant or not? I get the perception part of that.
I don't think the question really is about the mats. I think the question is whether or not oil and grease was, I mean, at least that's my understanding. That's what the city was concerned about, right? The oil and grease issue?
Correct.
Yeah, I mean, we have before been verbally told that you can't wash the mats out here because they have grease from the back of the house. And I've explained to the person who in the past has come by and mentioned that, the same situation. So we were under the impression that that was one of the main issues. You guys were worried about the the rubber mats in general being the problem and the issue of why, when they're rinsing those off, that's where the oil is coming from. In this specific situation, I'm gonna guess that it came from those pots that he had a picture of that were out back. Again, I don't know why they were there. It's not a normal thing for us to have them there. I don't know if our grease trap or the oil trap was overflowing. I'm not sure.
I'm no expert, but it looks like grease to me.
No, yeah, that's what I'm saying. It could have been full and they left the pots out there at the time, so when they were spraying things down, it overflowed into the floor. I'm not sure. So I'm not denying that at all. There's pictures. It very well could have happened.
So the city wants to, I guess if I read correctly, the city wants to charge you the $826 it was to clean the storm drain, and what was the fine you were seeking?
$1,000.
And they'd like to fine you $1,000. How do you respond to that?
We accept the fine.
All right, the storm drain issue is a big issue. I know that you know that, right? And they could have fined you $5,000 if they really wanted to. So they did go a little bit easy on you, but my suspicion is that if they find oil in that drain again, they're probably going to ask me for the max fine coming back. So it's important. I don't know anything about running a restaurant, I'll be honest with you. So I'm not going to tell you how to run your restaurant, but I will tell you, you got to be careful to make sure you don't put that oil in the storm drain. It causes real problems for the city and the people who live here.
Understood.
All right, in case CE 230401009, to make the following findings of fact and law. If I notice is sufficient, find the property in violation of 90.203. I hereby assess a fine in the amount of $1,000 and assess costs in the cleanup in the amount of $826. Thank you for coming in.
Thank you.
Case number 2 is rescheduled for 11 Maddox Street, CE 230400131. Number 3, 361 Westminster Place, CE 230406161. Number 3.
Good morning, John Frosco, West Palm Beach Cone. This property was cited for unsanitary conditions, excessive flora overgrowth, obstruction of the sidewalk, and hurricane hazardous trees and vegetation. It was also noticed that they were given 10 days to comply on this, or a possibility of abatement, the 215B. This originally came in as a complaint from a Mr. William Sned, who
Is this
has
a vacant? This is not a vacant.
I have no idea. I had no contact with the owner. I have no idea what's going on with this property.
It's like a jungle.
Yeah, it's pretty bad. the complainant, Mr. William Schned, who owns the property at 3030 South Dixie Highway, made the complaint. So it was generated on April 14th of 2023, and the property was posted on April 14th of 2023 and posted at City Hall. Certified mail was sent. Shows that certified mail was returned on 2025. Also, regular mail was mailed. Hasn't come back. Could we show the pictures of my morning inspection? I took pictures of it currently this morning. There's the obstruction of the sidewalk. That's on the Dixie Highway side. The house faces Westminster.
Just for the record, that obstruction, can you just describe it, what we're looking at?
You have vegetation that actually crosses into the sidewalk, into the public right of way. And you also have the debris that's washed up on the sidewalk.
So you've had no contact with anyone about this property? They have, I guess.
No,
they didn't.
sir. I asked Mr. Schned if he knows whether the property is occupied or not. He said he thinks so, but I don't know. It's pretty bad, and it smells pretty bad too.
Mr. Schned is the owner?
No, he's the neighbor. He's the
He's the
complainant.
neighbor.
Right. He has the business on 3030 South Dixie Highway, and the complaint came in originally because of the hurricane hazardous trees and the amount of vegetation that blows into his parking lot, which is next door.
Yeah, he must love this.
What the city is requesting is 20 days to abate, and the reason why I'm asking for 20 days is because I won't be here, and I want to supervise the contractor when he does this work because it's pretty significant.
A couple of questions. Is there an executed
Yes.
affidavit of posting in your file?
Yes,
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
yes, they are.
Just for the record, do I understand you're asking to give the owner 20 days to bring these alleged violations into compliance, or you're asking, if not within 20 days, that the city then abate these alleged violations? Is that accurate?
That is accurate.
Do you believe that these, are you asking for an abatement on all of it or some of it? Or?
No, all of it.
Okay, and do you believe that these alleged violations rise to the level of a health, safety, and welfare violation?
They do.
In what way? How?
In what way? They do not allow the property to breed. Overgrowth, what that actually does is allow an excessive amount of insects and animals that love to have privacy when they die. So they squeeze into the overgrowth, and that's where they pass away, and creates an higher unsanitary condition for the neighborhood.
So it could also bring disease, it brings rodents.
Yes, they do.
And hidden dangers that can be in there because it's overgrown. Is
Yes,
that accurate?
asking the question specifically, the hurricane hazards, those become projectiles in heavy winds, the palm fronds. They don't need hurricane winds to actually fall. And in the proximity of that parking lot where people park their cars and actually come in and out, that could be dangerous.
Okay. And in terms of the 20 days, do you believe that's a reasonable amount of time that the property owner could get these, the overgrowth cut back and everything cleaned up?
I think it's more than a reasonable time, given that the volume of work that has to be done on this, and it's my belief that I at this point that I don't think the owner will do this.
Okay.
I need to be there when the contractor does this work so I can make sure that it's done accurately, and
Okay, and has there been any progress that you've seen at all?
no progress.
Very good, thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept an evidence the evidence case file in this case, including the documents listed as City's Composite Exhibit 1. I don't really have anything to ask you. I mean, presumably this is habitat for vermin, right? I mean, habitat for vermin, you got
Yeah.
all kinds of loose flora and fauna that...
It's hard to contain this. When I walked by this morning on the Dixie side, the smell was pretty bad. I
Yeah,
don't
I'm
know
sure
if it
that-
was a dead animal or just rotted debris, but it wasn't
I'm sure
pleasant.
the neighbors must be very happy.
Oh, they're not.
So you're looking for 20 days or abatement?
Yes, sir.
All right. In case CE 230406161, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of listed code sections. Specifically, I find there's excessive growth and weeds on the property in violation of 18106B. I find that there are dying trees and various flora on the property that constitutes a hurricane hazard in violation of 74.4C1. I find the grass and reeds on this property are overgrown in violation of 74.4C3. I find that there's vegetation that is impinging on the public's right-of-way in violation of 74.4C4. And I find that the right-of-way is needs to be cleaned up in violation of 74.4C5. I specifically find that the violations on this property constitute a threat to the health, safety, and welfare of the city of West Palm Beach, specifically hurricane hazards and habitat for vermin. I hereby order the respondent to bring the property into compliance within 20 days. In the absence of compliance, I hereby authorize the city of West Palm Beach to enter the property and abate any and all of these violations. I hereby assess the cost of said abatement against the property and property owner.
Thank you.
Number 4, 1361 7th Street, CE 230303885. Number 4.
Good morning, Officer Luster, West Palm Code. This property was posted on 4/25/2023, along with City Hall. Certified mail was returned to us on 3/30/2023. Upon posting of the property, I spoke with the tenant, and the property was cited for certificate of use and rental license that are in delinquent status. I'm asking for 10 days or $50 per day.
Thank you very much. Is there an executed affidavit of posting in your file?
Yes, ma'am.
And do you believe 10 days is a reasonable amount of time within which to bring this alleged violation into compliance?
Yes, ma'am.
Has there been any progress by the owner since you posted?
No, ma'am.
Okay. And any photographs that we reviewed, do they truthfully and accurately depict and represent this particular property for this case and the posting for this case?
Yes, ma'am. In regards to rental license delinquency, yes.
I'm sorry?
In regards to the rental license delinquency, yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept an evidence the magistrate case file in this case, the city's composite exhibit 1. So this is a certificate of use and a rental license?
Delinquency, yes, sir.
And how do we know the property is being rented?
Spoke to the tenant, and the license is delinquent for rental.
I'm sorry?
And the license is delinquent for the rental license.
So they had an existing license, they haven't renewed it, and you spoke to the tenant who's still living on the property?
Yes, sir.
Okay. And you've had no contact with the owner?
None.
All right, in case CE 230303885, I make the following finding of fact and law. I find notice is sufficient. I find the property in violation of 2232A and 22441. Specifically, there is a rental occurring at this property without a certificate of use or rental license. I give the respondent 10 days to come into compliance or fine of $50 per day may issue.
Thank you.
Number 5, 425 29th Street, CE 230400055. Number 5.
Good morning, Alex Oliver, Code Officer for the City of West Palm. This property was cited on April 5th, 2023. Certified mail was sent on April 6th, 2023. Certified mail was returned on April 12th, 2023. Both property and City Hall were posted on April 10th, 2023. There has been no contact with the owner of the property, and affidavit of posting was added to the case. Property was cited for 786 missing address characters on the alleyway.
Thank you very much. Just a couple of questions for housekeeping. Based on the affidavit of posting, was the notice of violation also mailed by regular first-class mail?
Yes.
And the photographs that we were reviewing, do they truthfully and accurately depict and represent the alleged violation that you've observed?
Yes.
And just very briefly, can you tell us what it is about no address characters in the alleyway that you believe makes this an alleged violation?
Yeah, basically there has to be address characters in the back of the alleyway for first responders and utilities and basically for everybody who has access to the alleyway.
And you didn't observe them anywhere?
No, and they haven't, and everybody else on the alleyway has them, and
Okay.
they have been complying.
Okay, thank you. And you mentioned that there's been no contact at all, so, and you've not seen any progress as
Yeah.
of your last inspection?
Yes.
Okay,
No.
thank you. And what time frame were you requesting and what fine?
Yeah, city's requesting 30 days for compliance or $25 a day after that.
Thank you very much. You believe 30 days is a reasonable amount of time within which to get house numbers and put them on the alleyway?
Yes.
Okay. Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents and evidence. The city's composite exhibit 1. Is that the front of the house?
That's the back.
That's the back.
The back alleyway. Yeah.
So where's the front? There's not numbers on the front?
On the
visible?
posting. When I posted the posting pictures, that's the front. Front is fine. Yeah. Yeah. But
Is that not a number, 425?
yeah.
So why is it in violation if the number's on the house?
Oh, they need to be in the back alleyway for in the alleyway, the right of way of the alleyway. So the front, it has it, but it has to be on the back alleyway as well, because there's a street in the back.
Oh, so they have this number, but they need another number as well.
In the back, yes.
Is that what the code section says?
Yeah.
I don't have access to my computer to bring up.
Yeah, I have
the
it.
actual
Owners and tenants of
language.
houses and buildings using a service alley shall post a number on the side of the building adjacent to and facing such the alley. So that's what they haven't done, right?
Yeah.
Okay. I come prepared. All right, case CE 230400055, I make the following findings of fact and lie. Find notice is sufficient to find the property in violation of 78-6. Specifically, they do not have a number posted on the side of the building adjacent to and facing the alley. Respondent has 30 days to come into compliance or a fine of up to $25 per day may issue.
Thank you.
Number 7, 1117 35th Street, CE 230302227, number 7.
Good morning, J. Francis, West Palm Beach Code Compliance. 1117 35th Street was cited on 3/9/23. Certified mail and regular mail was sent on 3/13/23. Certified mail was received on 3/14/23. Both the property and City Hall were posted on 4/20/23. Affidavit of posting was completed and put in the case. I have been in contact with a property manager. The property was cited for a fence permit, painting the structure, and address characters. As of this morning, the property has come into compliance with the address characters on the fence in the alleyway, the paint on the structure, and the fence permit is still pending. Therefore, the city is requesting an additional 60 days for the property to come into compliance. If they do not come into compliance, then the city is asking for $50 a day until compliance is achieved.
Thank you, Officer Francis. Is the photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, ma'am.
In respect to what you've observed, can you just tell us for the record with regard to the paint situation and the fence, what it is that you believe leads to an alleged violation?
Well, on the fence, they didn't have any address characters as well as permit to put up the brand new fence. And right above the rear exit, there's a section of the structure that needs a bit of painting.
Okay, so to make the record clear, we're talking about a wooden fence
Yes.
that we're observing in the photographs, correct?
Yes. Yes.
Okay. And with respect to this area on the photograph that we're looking at now, that appears to be, what is this, the back of the house?
Yes.
Above the patio or porch?
Yeah.
It's an area of discoloration.
Yes.
Is that something where they could pressure wash And would that clear it up? And if it doesn't clear it up, that's when they would need to paint? Or
They did pressure wash it.
oh, they did pressure wash,
Yes.
so it's now
and
painting.
It needs just a bit of touch-up paint.
Okay, very good.
It
And
needs paint, huh?
Yes.
do you believe that 60 days is a reasonable amount of time? Oh, let me ask on the fence, is there any record that they've submitted a permit or anything?
Yes, they've applied for the permit.
Okay.
They're just waiting for it to be printed.
Okay, very good. Do you believe that 60 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes, ma'am.
Okay, thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, the permit application, and any and all other documents relied upon.
Without objection, I'll accept those documents and evidence. The city's composite exhibit 1. All right, so we just need the paint, and they need to pick up and pay for their fence permit. Is that essentially it?
And they'll be in compliance.
Okay. All right, in CE 230302227, I make the following findings of fact and law. I find notice is sufficient from the property in violation of 18106G. Specifically, there is discoloration on the building that needs to be cleaned or painted. And 94302A3, the fence needs to have a permit issued by the city. I give the respondent 60 days to bring the property in compliance or fine of up to $50 per day may issue.
Number 8, 4011 Windsor Avenue, CE 230300427.
J. Francis, City of West Palm Beach, code compliance. This property was cited on 3/23/23. Certified mail was sent on 3/27/23. Certified mail was received on 3/31/23. Both the property and City Hall were posted on 4/20/23. The affidavit of posting was completed and put in the case file. I have also been in contact with this property manager as well. The property was cited for unpaved parking, garbage can placement, excessive growth, clean and sanitary, and landscape maintenance. As of this morning, the property has not come into compliance. Therefore, the city is requesting an additional 45 days for the property to come into compliance. If they do not come into compliance, then the city is requesting $50 a day until compliance is achieved.
Thank you very much. Just a couple of questions.
Sure.
In the affidavit of posting, does it reflect that the notice of violation was also sent by regular first-class mail?
Yes, ma'am.
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed?
Yes, ma'am.
Have you seen any progress at all?
They have cut the grass in the front of the property, but towards the back where the trampoline is, there's still a bit of overgrowth.
Okay. And can you tell us for the record what it is that you've observed that leads you to believe that these are alleged violations?
Well, they parked the car right in front of the door to the apartment. Because they parked on the grass so much, it's actually created a little driveway. You can see the dirt patterns there. The garbage can is right out in the front at all times, and they need a bit of sodding.
Okay, and that sod, can that also include approved ground cover?
Yes.
Okay, and when was your most recent inspection of the property?
This morning.
And are you still seeing the parking occurring?
Well, the car wasn't there this morning.
Okay. Throughout the time that, in the interim of doing your notice and this morning, have you seen the car still parked
Yes,
in an
multiple times.
inappropriate manner multiple times?
Right by the door, yes.
Do you believe that 45 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes, ma'am.
Okay. So you're seeing trash and debris strewn throughout the property, is that?
Yeah, the trash can is always on the front. They do have trash and debris from time to time, but they make sure to clean it up right away.
They do clean it up right away?
I clean it? No, they clean
Well,
it.
they don't.
Yes, ma'am.
Okay. So in other words, were you seeing trash and debris still today?
No.
No. So what is it that's still outstanding?
Garbage can placement, excessive growth, clean and sanitary, landscape maintenance.
Okay, so the parking is no longer out of
I
compliance?
didn't see it this morning,
Okay,
no.
very good. But you are still seeing trash and debris, is that accurate?
Yes, the garbage can is still up front. There's still a bunch of excessive growth, and yes, the property needs to be cleaned as well.
All right, very good. Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents and evidence. The city's composite exhibit 1. So if I understood you correctly, when you were talking to the city attorney, excessive growth, landscape maintenance, and trash can public view are the remaining outstanding sections.
Yes, sir.
And you wanted to give them 45 days. How much of a fine were you seeking?
$50.
All right, in case CE 2303047, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18106B. Specifically, there were grass and weeds in excess of 6 inches. I find violation of 18106K, landscape maintenance. The front, side, and rear yards need to be maintained in accordance with the city code. And of course, 7434A1H, the trash can is in public view. Respondent has 40 days to come to compliance or fine of up to $50 per day measure.
Thank you.
Number 9, 825 38th Street, CE 230300093.
Good morning. Don Williams, Code Enforcement. 825 38th Street was cited on March 6th of 23. Certified mail sent out on March 27th of 23. City Hall and the property posted on May 2nd of 23. The previous rental license expired September 30th of last year. I have made contact with the tenants. No contact with the owner of the property. My recommendation is 10 days for the business for the rental license, 10 days, or one-time fine of $250, and for the COU, 10 days and $100 a day thereafter that.
Thank you. Just a couple of questions. Is there an executed affidavit of posting in your file?
Yes.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes.
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the posting of the notice of violation at this property for this case?
Yes.
You communicated with the tenants. Approximately when was your communication with them?
At the posting on May 2nd.
Okay. And have you seen any, you haven't seen any progress in terms of them submitting a rental application or anything like that?
Nothing at all.
Do you believe that 10 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents and evidence as city's composite exhibit 1. Sorry, I didn't hear. How do we know this property is still being rented?
The tenants.
You spoke to the tenants?
Spoke with them on May 2nd.
I'm sorry?
Spoke with them on May 2nd.
And you spoke with the tenant?
The tenants, correct.
Yeah. Okay. All right, in case CE 2303093, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 2232A, that there is no certificate of use for the rental property, and 22441, that the rental license has expired. Give the respondent 10 days to bring 2232A certificate of use into compliance, or a fine of $100 per day may issue. I give the respondent 10 days to obtain their rental license, or a one-time fine of $250.
Number 10, 4210 North Terrace Drive, CE 230300132.
Don Williams, Code Enforcement. This property was cited on March 6th of 23. Certified mail mailed out March 27th of 23. City Hall and the property posted May 2nd of 23. The previous rental license expired September 30th. It was not renewed by the owners. No contact with the owners. However, there is contact made with the tenants, and that was made May 2nd of 23 during the posting. My recommendation is 10 days to comply, or a one-time fine of $250 for the rental license, and a 10-day or $100 per day for the certificate of use.
Thank you very much. Is there an executed affidavit of posting in your file?
Yes.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes.
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the posting of this notice of violation at this property for this case?
Yes.
Thank you. Have you seen any progress with any resubmitted application?
No.
Okay. And you had mentioned that, again, you spoke with the tenant at the time of posting of the property in early May of 2023. Is that accurate?
That's correct.
All right. And do you believe that 10 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents as evidence as the city's composite exhibit. Sorry, one more time. How do we know this is rented?
Vote with the tenants on May 2nd during the posting.
Okay. And you were still seeking the 10 days for each one?
Correct.
All right, in case CE 230303132, I make the following findings of fact and law. I find notice is sufficient from the property in violation 2232A and 22441. As to 2232A, I give the respondent 10 days to come to compliance or a fine of up to $100 per day may issue. As to 22441, I give the respondent 10 days to come to compliance or a one-time fine of $250 may issue.
Number 11, 925 37th Street, CE 2303046.
Don Williams, Code Enforcement. This property was cited on March 7th of 23. Certified mail mailed out March 28th of 23. City Hall and the property posted May 2nd of 23. Cited for a rental license and certificate of use. The previous license expired September the 30th. There's no indication that they attempted to renew that license. Contact not with the owner, but contact with the tenants. Phone call made to me on May 3rd of 23 concerning the posting, and I indicated to them that it was for the owner of the property. My recommendation for the rental license is 10 days, one-time fine of $250, and the certificate of use 10 days and $100 a day thereafter.
Thank you. Is there an executed affidavit of posting in your file?
There is.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes.
Photograph that we've been reviewing, does it truthfully and accurately depict and represent the posting of this notice of violation for this case at this property?
Yes.
Thank you. Do you believe that 10 days is a reasonable amount of time within which to bring these alleged violations into compliance?
I do.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents as evidence as city's composite exhibit. All right, in case CE 2303046, I make the following findings of fact and law. I find notice is sufficient to find the property in violation of 2232A, certificate of use. Is required for property when operating a business or rental property. Respondent has 10 days to bring that into compliance or $100 per day may issue. I find the property in violation of 22441, rental license required. And there's a rental license required when renting a property. Respondent has 10 days to come to compliance or a one-time fine of $250 may issue.
Thank you.
Number 12, 1540 Palm Beach Lakes Boulevard, number 120, CE 230407170.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On April 10th, the business at 1540 Palm Beach Lakes Unit 120 was cited for signage requirements. Remove or reduce signage on window and rear of business. Business was posted as well as City Hall on May 1st. Certified mail as well as regular mail went out April 18th. Certified mail was signed for April 21st. I did have a conversation with the manager at the location to go ahead and reduce the window signage he has in the rear of the property and replace it with the type of sticker that he has with his logo of his business out front. I was under the impression that he was going to remove the window coverings in the rear. He attempted to remove a majority of it, but it's not completely completed. So with that being said, City is recommending 15 days to bring the property into compliance or $100 a day until compliance is achieved.
Thank you very much. Is there an executed affidavit of posting in your file?
Yes, ma'am.
The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violation that you've observed?
Yes, ma'am.
With respect to the posting at the property, there is a photograph. Did you also hand deliver that notice to that manager at the time?
Yes, ma'am.
And did the manager, how do you know that this person was a manager? Did they identify themselves as that?
He stated that corporate wanted him to be here at the hearing, but he has not shown up as of yet. So, yes, he did identify as the manager of the business.
Thank you. Do you believe that 15 days is a reasonable amount of time within which to bring this alleged violation into compliance?
I do.
And just for the record, we've seen a lot of pictures. So the business is that Marco's Pizza, just for the record?
Yes, ma'am.
Okay, thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
All right, without objection, I'll accept those documents as evidence as city's composite exhibit. All right, so this is a window signage issue. I believe, if I remember the code correctly, you can't cover more than 25% of the windows.
The window pane, correct.
Right. And so it's your, well, I guess we can see from that image, especially on the back, that covers 100%, it looks like.
Yes, sir.
Right. So is that the concern, or is the front one also a concern?
No, the front is fine.
So it's just
the front was an example that I gave to him to put in the rear. But I mean, I don't know. I'm trying to give him an opportunity to do the right thing.
all right. So in the rear, more than 25% is clearly covered. So you wanted to give him 15 days, and what fine were you looking for?
Correct.
I'm sorry.
Yes, sir.
And what size of fine were you looking for?
$100 a day until a compliance is achieved.
And you said you talked to him, and he said he was going to make efforts to bring it into compliance?
Yes, because he did make attempts. Like I said, he took 2 or 3 panes off, but he didn't finish. So to me, that's a good faith effort. So I'm trying to give him a little more time to get the rest done.
Okay. All right, in case CE 230407170, make the following findings of fact and life. Find notice is sufficient to find the property in violation 94-110C6. Specifically, the window signage is in violation of the code by covering more than 25% of the pane. Respondent has 15 days to bring the property into compliance or fine of up to $100 per day issue.
Number 13 is complied, 3154 El Camino Rail, CE 230400250. Number 14, 1932 Stratford Way, CE 230400251.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On April 22nd, the property at 1932 Stratford Way was cited for rental license and certificate of use. This rental license did expire in September 30th of 22. The property as well as City Hall was posted April 28th. Certified mail as well as regular mail was sent April 25th. Certified mail was returned May 8th. Due to the activity on the property and the expired rental license, I made several attempts to make contact with the property owner. I left numerous messages. No one has returned my phone call. So I'm trying to make another attempt with the notice of violation to make contact with this owner to get everything renewed and up to date. City's recommending 10 days to renew rental license, make payment, or $100 a day until renewal is made or compliance is achieved.
Thank you. Is there an executed affidavit of posting in your file?
Yes, ma'am.
And the photograph that we've reviewed, is that a truthful and accurate photograph of the posting of this notice of violation for this case at this property?
Yes, ma'am.
And with respect, you said that you saw or observed activity on the property that leads you to believe that it is still being rented.
Yes,
Can
ma'am.
you describe a little bit more about that?
Just things out on the porch, things of that nature, looks inhabited. So this is my intent. My observation is someone is still residing in the unit. I'm still trying to make contact with the owner to repute that, and not getting my phone calls returned.
Did you have an opportunity at all to see about any type of utility accounts? What names they have?
This is a townhouse, so utility accounts does me no good here.
So it's what?
This is a townhome, so utility accounts does me no good here, because it's usually the HOA that takes care of that.
Oh, excuse me.
Yeah,
Okay,
yeah.
thank you very much. Okay. Do you believe that 10 days is a reasonable amount of time within which to bring these alleged violations into compliance?
If anything, it's more than enough time to get it paid or at least make contact with me.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified, mailing
I'll accept
documents.
those documents and evidence as city's composite exhibit. I gotta say, I'm a little concerned about whether or not we really can show that they're renting the property. I mean, you haven't spoken with the tenants, right?
No, sir.
So other than the fact that there may be some evidence that somebody's living there, we don't really have any evidence that it's being rented.
Yeah, I haven't spoken to any tenants there. I'm still trying to make contact with the owner to determine if it indeed is still being rented or not.
I'm going to suggest we table this until the next hearing and see if you can find some evidence that somebody's actually renting this thing.
That's fine.
All right. Table.
Number 15, 629 52nd Street, CE 230203551.
City of West Beach Code Compliance, Robert Watkins. This property was cited on February the 28th. Certified mail was sent March the 1st. Certified mail was received March the 3rd. The property City Hall was posted on April the 3rd. This property was cited for certificate of use, rental license, address characters, and garbage can placement. As of yesterday, none of the violations have come into compliance. I have seen workers there, maintenance workers working, doing windows and that on the inside, but they didn't speak English to the gentlemen that were there. The city is requesting 30 additional days and or $100 per day after.
Thank you. Is there an executed affidavit of posting in your file?
Yes.
Did that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes.
The photographs that we've been reviewing, do they truthfully and accurately represent and depict the alleged violations and posting that you of the notice of violation in this case for this property, and also the alleged observations of the violations that you made?
Yes, ma'am.
We're reviewing several photographs for the record that have a for rent sign as of 2/23/23. And what is your most recent inspection of this property?
I went by there 2 days ago. I went by there yesterday as well. The for rent sign has been moved to the middle of the back side of the yard. You could barely see it. I did call the number on the front because it was the same individuals in another case I had that also told me the house was for rent. They were just finishing up the little unpermitted work they've been doing and that it would be for rent. They gave me the price and everything that it would be.
Thank you very much. And with respect to what you're seeing for the garbage can placement, is it an empty garbage can that's out outside of the times for the garbage to be picked up? Is that what you're seeing from the road? Or
It's
from the
always
right-of-way?
in the gate. It's still in the gate now. As of yesterday, it just had building materials in it. So I doubt it was put out because it wouldn't have been picked up with the building materials in it. So yeah, it's still visible.
Okay. And you're not seeing any numbering characters on the front?
Not on the home itself, no. They've changed the front door and everything around it. The numbering characters used to be on the front of the home. Periodically, the 9 will come off where the mailbox is. It was up in the picture, so I took it that it was up. But they took them off to do the painting and stuff and never put them back.
Thank you very much. Do you believe the 30 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes, ma'am.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents and evidence, the city's composite exhibit. So you spoke to the person that's renting the property. Did you explain to them that they needed a rental license?
Yes, absolutely. I called the number, the same number that I called on 50th Street, because I seem to have bought up a few, the company, and they put them all for rent. And they're all doing work without permits. They're all doing the exact same thing. And I've got the price and how much it is every month and everything, every time I place the call.
To the best of your knowledge, they haven't applied for a rental license at this point?
As of yesterday, there was no rental license on any of the properties they've purchased.
Okay. All right, in case CE 230200351, I'm sorry, how much of a fine were you looking for?
$100, sir.
In CE 230200351, I make the following findings of fact and law. I find notice is sufficient from the property in violation of 2232A, 22441, 7434A1J, and 78-6. Specifically, I find that there is no certificate of use for a rental property, that the rental license is missing. I find that the garbage can is clearly visible from public view, and I find that the number address characters are missing from the front of the home. You give the respondent 30 days to come into compliance, or a fine of $100 per day may issue.
Number 16, 615 59th Street, CE 23030-182.
City of West Mutual Code Compliance, Robert Watkins, Code Officer. This property was cited on March the 8th. Certified mail was sent March the 9th. Certified mail was returned March the 15th. City Hall was posted April the 3rd. This property was cited for trash and debris, excessive growth, fence maintenance, garbage can placement, and window screens. As of yesterday, the compliant violations were the trash and debris, fence maintenance, and window screens. Remaining violations are the excessive growth and garbage can placement.
Is there an executed affidavit of posting in your file?
Yes, there is.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes, there is.
Photographs that we've been reviewing, do they truthfully and accurately depict and represent your alleged observations at the property as well as posting?
No, those weren't the photos that were on the screen.
I'm sorry?
No, it didn't. Those weren't the photos. Those are the photos.
Okay. So these photographs that we're now reviewing, are these the photographs of this particular property for this case?
Yes, ma'am.
And do these photographs truthfully and accurately depict and represent the alleged violations you've observed?
Yes, ma'am.
And also truthfully and accurately depict and represent the posting of this notice of violation for this case at this property?
Yes.
What is it about the excessive growth and garbage can that you observed that leads you to believe these are alleged violations?
I see the garbage can outside as I ride by. The excessive growth is right along the front, right there. There's some in front of the home as well with the rental unit. The excessive growth also is on the west side of the home. The fence in disrepair, there were some slits that were missing, and just as you can see in that picture, they were just laying there along the fence. Window screen, the main window right below the address characters didn't have a screen in the window. And of that one right there, you see the fence and the slits that are laying there with the trash and debris.
Okay, and just to reiterate, you indicated that the fence was now brought into compliance and the window screens were now brought into compliance. Is that accurate?
Yes, ma'am.
Just for the record, again, you sent the notice of violation, or excuse me, you posted the notice of violation at this property. Is that accurate?
Yes, there is.
And what type of a time period are you seeking and a fine are you seeking?
30 days, additional days at $100 per day after.
Thank you. Do you believe that 30 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes, ma'am.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents as evidence as city's composite exhibit. So we're still missing the window screens.
No, the window screens are there. It's the excessive growth and garbage can placement.
Is that all that's left is excessive growth and garbage can placement?
Yes.
And how many days and what fine were you seeking?
30 days, sir.
And the fine amount?
$100.
All right, in CE 23030-182, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18106B and 7434A1J. Specifically, there is grass and weeds in excess of 6 inches, and the garbage can is in public view. Respondent has 30 days to come to compliance or fine of up to $100 per day issue.
Number 17, 5709 Pinewood Avenue, CE 23030-184.
City of Westbridge Code Officer Robert Watkins. This property was cited on March the 8th. Certified mail was sent March 9th. Certified mail was returned May the 1st. City Hall was posted April the 3rd. This property was cited for trash debris, clothing hanging on the fence maintenance, sodding of yard, landscape maintenance, outdoor storage, and appliances being kept outside with the doors on them. Compliant violations are the appliance with the doors on it, clothing hanging on the fence, and fence maintenance. Remaining violations are trash debris, sodding of the yard and bare areas, landscape maintenance, and outdoor storage. The city is requesting 30 additional days at $100 per day after.
Thank you. Is there an executed affidavit of posting in your file?
Yes.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes, it does.
Was the notice of violation posted to the property?
Yes, it was.
The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed?
Yes.
With respect to the remaining alleged violations, could you just please tell us for the record what it is you observed that leads you to believe these are alleged violations?
When it comes to outdoor storage, there is a ladder stored out front. There's a bin of some sort out front. And it should be by the front door, there's also like a receptacle bin. When it comes down to the landscape maintenance, there's areas in the yard where there's none at all. There's some where it's overgrown towards the front of the house. You can see it in the picture there. When it comes to the trash debris, there's still trash and debris that's just all around the yard in the swell.
And anything additional with the landscape maintenance?
No, ma'am, nothing additional to that.
Okay. So in other words, if they get sodding or approved ground material, would that take care of the landscape maintenance as well? Is that
Yes,
what you-
ma'am, because
Okay.
it's watering, it's making sure it's there, all that's covered under maintenance.
Okay. So they've made progress with some things brought into compliance. Have you had any further contact with anybody from the property?
No, ma'am.
Okay. Do you believe that 30 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents as evidence. The city's composite exhibit. The appliance doors, is that still an issue?
No, the refrigerator that was out there is gone. They've either taken it away or had it picked up for disposal.
And the clothes are gone?
Yes, the clothes have dried and they're off the fence.
And the fence and wall maintenance?
They repaired the fence that the clothing was hanging on.
So that's repaired? So we're just talking about the landscape, which is missing sod, the trash and debris on the property, the other landscaped.
Yeah, the ones that are left were the trash debris, sodding of the yard, landscape maintenance, and outdoor storage, which is, I don't know what that, pillows and things like that that are just,
Okay.
they're still outside.
And you said 30 days or $100?
Yes, sir.
All right, in case CE 230300184, I made the following findings of fact of law. I find notice is sufficient. I find the property in violation of 18106M. Specifically, the area the landscaping needs to be maintained and irrigated and cut where it's overgrown. 18106A, there's trash and debris on the property. 94442C1, the landscaped areas have to be sodded. And 9471C, the outdoor storage, including the ladder, other materials, and receptacles have to be removed. Oh, I'm sorry. Respondent has 30 days to come to compliance or fine of $100 per day issue.
Number 18147 Gregory Road, CE 2303038.
Richard Pazmino, City of West Palm Beach Code Enforcement. This case was originally created by Code Officer Joe Oliva. This property was cited on April 20th, 2023. Certified mail was sent out April 21st. It was returned. In addition, the property and City Hall were both posted on April 20th. Affidavit of posting is in the file. The photo of posting is in the file. And the notice of violation, notice of hearing was also sent via first-class mail. This property was cited for certificate of use and rental license, delinquent, unpaid balance. Since taking over the case on May 5th, I've had no contact with anyone from this property. The delinquent balance has been paid. but looking into the rental license for this property, the rental license was never issued since being applied for in 2017. They've just been making the yearly payments, even though they've never actually been issued the license. I left a voicemail with the owner, the phone number on the application on May 12th. I explained that he needs to obtain the state DBPR license for vacation rental. I've had no contact since. The city's recommending 30 additional days to comply to get the license issued, or a fine of $150 a day.
Thank you very much. And the photograph that we reviewed, it's a truthful and accurate depiction of the posting of this notice of violation at this property for this case. Is that accurate?
Correct.
Okay, and I know you said that they brought the delinquency into compliance, but basically they had submitted an application for rental, and they keep paying it every year, potentially late. And so they've, it's your understanding that that acquiescence would show that they're definitely still renting. Is that, would that be your testimony?
Yes, they're still out of, they're still in violation of these code sections since they don't actually, they've never obtained it.
So not only would they have to get the rental license issued, but they have to get the COU by getting inspections. Would that be accurate?
I believe they have all the inspections. They're just failed from the front desk in the category Department of Business Regulation.
Okay, got it. And 30 days a reasonable amount of time within which to obtain what they need from DPPR and to get that issued from the city?
Yes, and if they're not doing vacation rental, they could just remove that by coming to the city as well.
I'm sorry, I didn't.
They have two choices. They need to get that from the state, or they could come to the city and remove that vacation section and not rent it as a vacation rental.
Excellent. Thank you so much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
All right, without objection, I'll accept those in evidence as city's composite exhibit. So this is a vacation rental, is that it?
Their original application says vacation rental. They checked the box that says vacation rental.
I guess the fact that they keep paying it is evidence that they think it's being rented.
Yeah, since being cited on April 20th, they made the payment.
But so if I understand you correctly, I was trying to follow the conversation. If I understand this correctly, they're paying the rental fees, but they haven't submitted the request for the rental license.
No, the application's in. They've even done the inspections. They're not. There's one section in the inspections for the Department of Business Regulation for that state license.
Oh, so they didn't get the DBR approval.
Yeah, they haven't sent it to the city. If they have it.
And you wanted to give them 30 days to do that?
Yes.
And you were seeking $150 per day after that?
Yes.
All right, in case CE 2303038, I make the following findings of fact and law. I find notice is sufficient enough on the property in violation of 2232A and 22441. Specifically, to complete the rental approval, they need to send their DBR to the city by within 30 days or fund up to $150 per day may issue.
Number 197512 South Dixie Highway, CE 2303014.
Richard Pazmino, City of West Palm Beach Code Enforcement. This case was originally created by Code Officer Joseph Oliva. This case was cited on March 23rd. Certified mail was sent out March 24th. It was signed and received on March 28th. In addition, the property and City Hall were both posted on March 24th. There is a photo of the posting in the attachments. The affidavit was turned in, and in addition, the notice of violation, notice of hearing, was sent via first-class mail. This property was cited for landscape maintenance, failure to comply violations, trees, hedges obstructing the right-of-way, and swale parkways not being maintained in a healthy, neat appearance. These are in relation to there's a road at the back of this property, behind a wall. The vegetation on the property side is not being maintained, not being cut back. It's growing and overhanging into the street. The swale area accumulates trash from just being overgrown. Since taking over this case on May 5th, I've had no contact. As of today, all violations still remain. The front of the property looks good, so they are maintaining that. The back remains untouched. It's overgrown, hanging into the road. The city's recommending 14 days to comply with these violations, or asking for a daily fine of $75 a day.
Thank you very much. The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes.
Is 14 days, in your estimation, a reasonable amount of time within which to bring these alleged violations into compliance?
Yes.
And with respect to, this is like a commercial plaza, or?
Yeah, it's a commercial strip. It's a Dunkin' Donuts at that location.
Okay, you indicated that you've not had any contact. You are seeing some progress. So as of today, all of these alleged code violations remain outstanding?
Correct.
Excuse me. Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept as an evidence the city's composite exhibit 1. So basically, we're just talking about the rear of the property where you have this overgrowth and impingement onto the right-of-way here?
Yes. Every other business on that block is maintaining it. You can kind of see right there.
You wanted to give them 14 days or $75?
Correct.
All right, in case CE 230301414, I make the following finding of fact on life. I notice is sufficient to find the property in violation of 18106K, 18215B, 744C4, and 9874C specifically. There's overgrowth in the rear of the property that's impinging upon the right-of-way and not being maintained in a healthy and neat appearance. Respondent has 14 days to bring the property in compliance or fine of $75 per day, Mission.
Number 2360 Alhambra Place, CE 230400047.
Richard Pezmino, City of West Palm Beach Code Enforcement. This case was originally created by Code Officer Joseph Oliva. This property was cited on April 5th. Certified mail was sent out April 6th and signed, received on April 7th. In addition, the property and City Hall were both posted on April 6th. The photos, the affidavit of posting are in the attachments. In addition, the notice of violation and notice of hearing was sent via first-class mail. This property was cited for certificate of use and rental license required. The property is advertised for rent. They have a for rent sign on the property. Since taking over this case on May 5th, I spoke to the phone number on the sign that's in the yard on May 12th, and I got an email from my manager, Mark Joyce, who also spoke to the owner. They are out of town, but they're going to take care on getting it done. They do have the application in. They're just pending the code enforcement inspection. So with that being said, the city's recommending 30 additional days to pass the code enforcement inspection and get the license, or a fine of $100 a day.
Thank you very much. The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed on this property for this case?
Correct, yes.
Okay. And do you believe that 30 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes, definitely.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, emails, and application, and any and all other documents relied upon.
Without objection, I'll accept those documents as evidence the city's composite exhibit. Case CE 2304047, make the following findings of fact in law. Find notice is sufficient to find the property in violation of 2232A and 22441. Specifically, there is a property being offered for rent. It does not have a rental license or a certificate of use. Respondent has 30 days to come to compliance or fine up to $100 per day admission.
Number 21, 1014 Bradley Court, CE 2304039.
This case complied this morning.
Number 22, 1015 Bradley Court, CE 2304049.
This case also complied this morning.
Number 23, 1115 Summit Boulevard, CE 230400201.
Richard Pasmino, City of West Palm Beach Code Enforcement. This property was cited on April 18th. Certified mail was sent out April 19th. And it was received for on April 21st. In addition, this property and City Hall were posted on April 19th. The affidavit of posting, photos of posting are in the attachments. In addition to this, the notice of violation and notice of hearing was sent out to the property owner via first-class mail. This property was cited for trash and debris on the property. You can kind of see it there in that photo. They were storing the garbage cans in public view right on the property line in the front, visible from the street, and outdoor storage being stored kind of against the house, in front of the house. I've had no contact. As of this morning, the only remaining violation is for the garbage can placement. They did move it, but it's being stored against the side of the house now, but still visible to the public. The city's recommending 10 additional days to comply this, to move the garbage cans behind a fence, or a fine of $25 a day.
Thank you very much. The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, they do.
Do you believe that 10 days is a reasonable amount of time within which to bring this alleged violation that still exists into compliance?
Yes, they do.
10 days is reasonable?
Yes. I'm sorry, yes.
That's
Yeah, I've had history of dealing with this. The owner of the property, usually she's really responsive and reaches out. She didn't reach out this time, so.
But they did make progress on everything.
Yeah, they cleaned up all that trash that was being stored out there for weeks.
Excellent. Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents and evidence. The city's composite exhibit. So we're just talking about the trash can?
Yes, they need to move it behind the fence.
So the outdoor storage is gone and the clean and debris is good?
Yes. Yeah, they removed all of that.
Okay. All right, in case CE 2304020, I make the following findings of fact and law. I find notice is sufficient to find the property in violation of 7434A1H. Specifically, the trash can has to be removed from public view. Respondent has 10 days to bring the property in compliance. What was the fine you were looking for?
$25 a day.
Fine of $25 per day admission.
Thank you.
Number 28, 3940 North Flagler Drive, number 402, CE 2302048, number 28.
Good morning, Officer Levine, City of West Palm Beach Code. This property was cited for failure to obtain a certificate of use and rental license. Notice was sent by regular mail and certified mail. Certified mail was signed for on April 17, 2023. The property and City Hall was posted on April 18, 2023. I've had no contact with the property owner, and there isn't a license in the system or an application in the system for this property. Now, on April 19th of this year, which was almost a little over a month ago, I brought one of these properties before you, and when I went to post the property, the security at the gate had to take me up to these properties to have me post them. And security was the one who informed me that the additional units at this location was being rented by the property owner, as well as the advertisement in online. So the city is requesting 30 days to come into compliance, or $200 a day thereafter.
Thank you very much. Is there an executed affidavit of posting in the file?
Yes, ma'am.
And the photograph of posting, is that an accurate photograph of the posting of this notice of violation for this property in this case?
Yes, ma'am.
Is 30 days a reasonable amount of time within which to bring these alleged violations into compliance?
Absolutely.
Thank you very much. You didn't see any type of an application as of this
No,
morning?
ma'am.
Okay, thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photograph, the internet posting of the rental, and any and all other documents relied upon.
Without objection, I'll accept those documents as evidence, the city's composite exhibit. Do you have any contact with the owner on this at all?
No, sir. According to security, when I did the first property, the individual came down from Chicago to apply for the license for that previous case as well as these other properties, and we haven't seen anything in the system thus far.
$5,000 a month for 2-bedroom, huh?
So,
All right, case CE 230202448. I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 2232A and 22441. Specifically, they need a certificate of use and a rental license to rent a property in the city of West Palm Beach. Respondent has 30 days to come into compliance. A fine of $200 per day may issue.
Number 29, 3940 North Flagler Drive, number 306, CE 230400088.
this property too was cited for failure to obtain a certificate of use and rental license. Notice was accomplished by regular mail and certified mail, which was signed for on April 17, 2023. The property was posted on April 18, 2023. And like the previous case, even though you're seeing the previous case was an LLC, it is the same owner. Just two properties have an LLC, 2 properties have the owner's name. I've had no contact with the owner. There isn't an application in the system for a license. And again, security was the one that informed me that these properties being rented and occupied. So the city is requesting 30 days to come into compliance with $200 a day thereafter.
Thank you. Is there an executed affidavit of posting in your file?
Yes, ma'am.
And was the notice of violation posted at City Hall?
Yes.
Photograph, I'm not sure that I heard appropriately. What did you say about the application?
There's no application in
No
the
application. And no contact from the owner?
No contact with the owner.
So no progress that you're seeing at all?
No, ma'am.
That photograph is a photograph of this notice of violation for this property, for this case, at this address?
Yes, ma'am.
And again, can you just reiterate what it is that leads you to believe that this is being rented?
Information received from security at the gate, who took me to post a previous property owned by this owner.
Okay. And do you believe 30 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Absolutely.
Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those in evidence, the city's composite exhibit. Case CE 230400088. Make the following findings of fact and law. I find notice is sufficient. I find the property is being rented in violation of 2232A and 22441 without a rental license or certificate of use. Respondent has 30 days to come to compliance or fine up to $200 per day issue.
Number 30, 500 Executive Senate Drive, 5E CE 230400102. That case is removed. It was the new owner the day before it was cited, so we have to remove that. Number 31, 2831 Exchange Court, number D, CE 230400196.
This business was cited for failure to renew its business tax receipt. And also for BTR penalties, certified mail. Notice was accomplished by certified mail and regular mail. Certified mail was signed for on April 21, 2023. The business was posted on April 25th, 2023. I've had no contact with the business owner. There's a balance due of $1,410.87 on this business. Now, this is a tax preparer. He also does immigration, notary, to name a few. And I haven't been able to get in contact with this person. Prior to me citing the business, I wanted to verify that the business was still there. The owner was there, but I didn't get a chance to talk to him. So the city's requesting a one-time fee of $250. And let's see, verify something. Probably $50 a day for the certificate of use until compliance is achieved.
I'm sorry, how many days? How many days?
10 days. It's a renewal, so it's something that they could go ahead and pay online. And
So 10 days to pay the $1410.87?
yes, sir.
And that's all they have to do to bring the property into compliance?
That's all they got to do to bring the business into compliance.
Thank you very much. Is there an executed affidavit of posting in your file?
Yes, ma'am.
I may have missed it. Did you post the notice of violation to City Hall?
City Hall and the business.
Thank you very much. The business specifically is 2831 Exchange Court, and it's unit number D. Is that accurate?
Yes.
So the photograph that we're seeing of posting is for this notice of violation for this case, for this unit number D, for this business. Is
Yes.
that accurate? Okay. And it's your testimony that everything that you're seeing, you believe that this is an ongoing current business?
Ongoing current business. A lot of times we see tax preparer, and after tax season, they're no longer there, but there's immigration and other stuff going on at that location too.
Okay. 10 days, a reasonable amount of time within which to bring these alleged violations into compliance?
Absolutely.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents as evidence as city's composite exhibit. A certain amount of irony in a tax preparer being brought to code enforcement for failing to pay their tax. So you're seeking 10 days for them to pay the $1410.87
Yes.
or what fine?
$250.
All right, in case CE 2304019 I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 82143C and 82144. Specifically, they didn't pay their business tax receipt, or the respondent to pay their receipt within 10 days, or a fine of $250 per day may issue.
Number 32 is complied, 513 45th Street, CE 230200323. Number 33 is complied, 706 45th Street, CE 230300004. Number
34 and 35 is rescheduled.
34 and 35?
Yes.
Number 34, 623 45th Street, CE 230300365 is rescheduled. Number 35 is rescheduled, 640 40th Street, CE 230300407. Number 36, 1601 North Dixie Highway, CE 230300421.
Good morning, Officer Underwood, City of West Palm Beach Code Enforcement. Property 1601 North Dixie Highway was initially cited on March 23rd, 2023. Certified mail was sent out March 24th. City Hall and property were both posted on March 27th, and certified mail was signed and returned on March 27th. I have been in contact with this property owner that was cited for certificate of use and business tax receipt. They have applied for their business tax receipt and certificate of use, and we're just awaiting signage for the final inspection to go out there and approve it. So the city's requesting 30 additional days or $150 a day thereafter.
Thank you very much. Is there an executed affidavit of posting in the file?
Yes, there is.
Does that reflect that the notice of violation was also sent by regular first-class mail?
Yes, it does.
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes.
And you observed, it looks like that they were doing work on the cars on this property. Is it your testimony that this was more than just working on one personal car for, like,
correct. Yep.
changing a tire or
That's
something
correct.
like that? Okay.
Yep.
And you are seeing progress because they've applied and they just need inspections. Is that accurate?
Correct. They're awaiting proper signage for the business. So as soon as the signs come in this week, I'll go out and do an inspection to approve their application.
Got it. You believe 30 days is a reasonable amount of time within which to get this signage?
Should be plenty.
Okay, thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents to evidence as a city's composite exhibit. All right, case CE 2303041, I make the following findings of fact and law. Found notice is sufficient. I found the property in violation of 2232A and 82144, specifically doing business without a certificate of use or a business tax receipt by working on cars and car repair. Respondent has 30 days to come into compliance or fine of up to $150 per day may issue.
Number 37, 1619 North Dixie Highway, CE 2303043.
Good morning, Officer Underwood, City of West Palm Beach Code Enforcement. Property 1619 North Dixie Highway was cited March 23rd. Certified mail was sent out March 24th. City Hall and the property were posted March 27th. And certified mail was signed for and returned March 27th also. This property adjoins the previous case of 601, and I have been in contact with the property owner. And again, we're waiting on signage for the proper business for their application so I can sign off on his business tax receipt and his certificate of use. The city's requesting 30 additional days or $150 a day thereafter.
Thank you very much. Is there an executed affidavit of posting in your file?
Yes, there is.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes.
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, they do.
Just to make the record clear, you believe that this is connected to the other property, has the same owner, and your contact with that owner was part and parcel of also talking about the other property we just went through. And so is it your testimony that this owner understands what he needs to do with this particular property?
Correct.
Thank you. Is 30 days, in your estimation, a
Yes.
reasonable amount of time? Thank you. And Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those documents and evidence as city's composite exhibit. All right, in case CE 2303043, make the following findings of fact and law. Find notice is sufficient. Found the property in violation of 2232A and 82144, specifically running that auto repair business without a certificate of use or business tax receipt. Respondent has 30 days to come to compliance or fine of up to $150 per day may issue.
Number 38, 1042 Grant Street, CE 2303044.
This property is complied.
Number 39 is complied, 2100 North Australian Avenue, CE 230300489. Number 40, 913 Division Avenue, number 102, CE 230400063.
Good morning, Officer Underwood, City of West Palm Beach Code Enforcement. Property 1913 Division Avenue was initially cited on April 5th. Certified mail was sent out April 6th. City Hall and property were both posted April 7th, and certified mail is returned signed April 10th. This property was cited for repair interior walls, floors, holes in the walls, and bubbling in the paint. Plumbing fixtures, plumbing in the bathroom leaks. It was cited for kitchen and bathroom floors leaking water into the bathroom, and electrical in the kitchen. I have been in contact with the tenant and the property owner. They have complied the plumbing fixture in the bathroom underneath the sink where it was leaking. They have replaced the kitchen stove where the kitchen burners were not working. They've replaced it with a new one. Everything else exists after that. As you can see in the picture, the walls have bubbles with water in them. I did not poke a hole in the wall of that specific spot, but the tenant sent me a video of her lancing the paint and water dripping out of it, which is in the case file somewhere right there. You should see that bubble is full of water. It's a video.
Video by tenant.
This is one from the ceiling also that she submitted after a rainstorm from the tenant in the shower. And the next one is the bubbling paint.
Just squeeze it. Thank you very much. Is there an executed affidavit of posting in your file?
Yes, there is.
Does that reflect that the notice of violation was also sent by regular first-class mail?
Yes, it does.
Photographs and videos that we've reviewed, do they truthfully and accurately depict and represent the alleged violations that you've observed?
Yes, they do.
And what time frame and fine are you seeking?
The city's requesting an additional 30 days or $150 a day thereafter.
Thank you. Just to be very clear, of the 1, 2, 3, 4 alleged code section violations here, the only one outstanding is the alleged violation for 18103C for the holes in the walls and the bubbling of the paint. Is that accurate?
Correct.
Want to be very clear, this is for 1913 Division Ave. Is it unit number 102?
Correct.
Are there any other units involved in this particular case?
No, there is not.
Okay, thank you. And 30 days a reasonable amount of time within which to bring these alleged violations into compliance?
I believe so, yes.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, videos, and any and all other documents relied upon.
Without objection, I'll accept those documents and evidence. The city's composite exhibit. Case CE 230400063. I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18103C. Specifically, there are holes in the wall and bubbling of paint caused by water. I give the respondent 30 days to bring the property into compliance with 18103C, or a fine of $150 per day may issue.
18103H, that's complied? Is that right?
Yes.
Yes. Yep.
Thank you. Number 41, 1225 Palm Beach Lakes Boulevard, CE 230400127.
Good morning. Officer Underwood, City West Palm Beach Code Enforcement. Property 1225 Palm Beach Lakes Boulevard was initially cited April 12th, 2023. Certified mail was sent out April 13th. Both City Hall and the property were posted April 14th, and certified letter was signed, returned April 24th. This property was cited for clean and sanitary conditions, excessive growth, junk abandoned vehicles, and fence permits. I have been in contact with the property manager of this property, and they're having an issue with the white car that's in that picture. Somebody's living in that. So trying to have them tow the vehicle out with somebody being present has been difficult for them. She insists that she's sending somebody out here as soon as possible to get the grass cut down and all the trash and debris picked up. So therefore, the city's requesting additional 30 days or $150 a day thereafter.
Thank you very much. Is there an executed affidavit of posting in your file?
Yes, there is.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes.
The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, they do.
With respect to the white car, you talked about that being a junk or abandoned vehicle. Are you seeing any other vehicles, or is that the only one?
That's the main one. Some of the other ones, like that one specifically, comes and goes, so I can't prove that it's there all the time. But the other one has not moved in months, and there is somebody living in that vehicle.
Okay. And is it your testimony that there's is this just a lot, or is it a lot on a commercial?
It's a commercial property that they're going to be building on in the next 6-8 months, however long the time frame is, but it's going to be built on.
Okay. With respect, you're seeing trash and debris around the property. Is that accurate?
That's correct.
We're also seeing that in those photographs. True.
Correct.
Okay. And you're seeing grass and weeds that are overgrown. Is that accurate?
Correct.
And when was the last time that you went to the property?
Yesterday morning.
Okay, you're still seeing these trash and debris, the overgrowth. You're still seeing the junk and abandoned vehicle. Tell us about the fence. We're seeing a chain link metal fence. Is that what you're talking about?
Correct. The portable 6-foot fence.
Okay, and has there been any application for that? You've seen any progress on that?
As of yesterday, no.
All right. And do you believe that 30 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes, I do.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Without objection, I'll accept those into evidence as city's composite exhibit. Yeah, I don't really have any questions for you. I think you covered the landscape here. Case CE 230400127, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of 18106A. There is trash and debris all over this property. 18106G, the 18106B, the grass and weeds are in excess of 6 inches. 34102A, there's a broken or abandoned vehicle, specifically that white vehicle on the property. And 94302A3, there's a fence on the property without a permit. Respondent has 30 days to bring the property in compliance or fine of $150 per day may issue.
Thank you.
I think that's it for this, right?
Yeah, the first one.
All right, we're going to be in recess till 11:30 for other matters.
West Palm TV, we're ready.
All right, I hereby call this meeting back into order. This is the special magistrate meeting for the city of West Palm Beach. This is the other matters agenda. Cases are going to be heard in the order in which they appear on the agenda. When you hear your case heard, go ahead and proceed to the podium on my right-hand side. The city will introduce the case, then you'll have the opportunity to present to me what you'd like me to know. If you're doing a reduction of fine case, and that looks like all of these, it's important for you to tell me what you are asking me for and why I should grant it to you. It's also important to remember the requirements under the city code for reductions of fines. If you have any questions during the process, do feel free to ask them. This is a quasi-judicial hearing, which means that the formal rules of evidence do not apply. However, all testimony is taken under oath under penalty of perjury. So if you think you might testify today, or you're planning to testify, or there's a possibility that you might testify, would you please rise and raise your right hand and be sworn in? Anyone that might testify? Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? Right, please be seated. So you can call the first case.
It's okay with the special magistrate if we call number 6 first, because the code officer has to go somewhere? Okay.
Go ahead.
Number 6, 2919 Spruce Avenue, CE 21090079. Number 6, 2919 Spruce Avenue.
Cassandra Say Hilaire, Code Enforcement with the City of West Palm Beach. Case CE 210-90079 was cited on September 9, 2021. The property was cited for failure to obtain a rental license and certificate of use. The property was given 30 days or $200 a day to come into compliance. The property was out of compliance for 368 days, resulting in a lien amount of $73,600. Special Magistrate, the applicant was the cause of the violation. The city is seeking 25%.
Sir, can you tell me your name, please?
My name is Guy Rabidou.
And are you representing CKHR Florida LLC?
Yes, I am.
And you're an attorney, sir?
Yes, I am.
All right, the floor is yours.
My client bought this property with a pre-closing inspection. We believed everything was in order at the time of purchase. I have the inspection here if you'd like to see it. When we purchased the property, the client was not aware that he needed a rental license for it. And then when we went to get the inspections done for it, the tenant that was in the property refused permission to have access to the property on multiple occasions, even after the police were called to accompany the people to do the inspection. I believe the code enforcement officer will testify to that. We are seeking to have the fine reduced to $2,500 total, because we did everything we could reasonably do other than use physical force against the tenant, which obviously is not a choice for us.
Well, I would never recommend that. The city's seeking 25%?
Well, also, Code Officer Kevin Levine, who was the one that cited this property, he did want to speak on behalf of this case as well.
Okay.
All right.
Good morning once again, Officer Levine, City of West Palm. I was the one that initially cited this property for the rental license because there was an ad posted outside the property. It did come to a hearing, and after the case was adjudicated, they did apply for the license. However, when I went to do the inspection, the very first inspection, the tenant gave me a list of issues that were at the property. So at the time, I reached out to the property manager, who went ahead and started the process to get everything done. But for some reason or the other, the tenant turned out to be a very difficult tenant. And according to the attorney, some of what the attorney said, yes, I am privy to that information, that the tenant was a difficult tenant. Wouldn't allow the property management to go in and take care of what needed to be taken care of. And special magistrate, in good faith, my job is to obtain compliance. And I can't stand here and say, well, look, they didn't try in good faith. This property owner has 3 other additional properties in close proximity. Granted, he was a novice investor when he first bought this property, but after meeting with me to do the inspection, I informed him what he needed to do with all the other properties, and it was done without a hitch. Those properties are immaculate. So I would suggest that we go beneath that 25%, because, I mean, it was more of a tenant issue than a property owner issue.
What's the city's response to their offer of $2,500?
The city will accept 3. We'll settle on $3 grand.
Was that 3,000? I'm sorry.
City's offering $3,000.
We will accept that.
Sold. Reduced. How much time do you need?
15 days.
I'll give you 30. 30 days, $3,000.
Thank you.
Thank you.
Here's a copy of your order behind you.
Thank you.
Okay, next case is number 1 and 2 for 923 Selkirk Street, CE 140604080 and CE 20070301.
Cassandra St. Hilaire, Code Enforcement with the City of West Palm Beach. Case CE 140604080 was cited on June 23rd, 2014. The property was cited for farm animals, garbage can placement, overgrowth, landscape maintenance. The property was given 7 days or $200 a day to achieve compliance. The property was out of compliance for 1,464 days, resulting in a lien amount of $292,800. These are the new owners. Magistrate, I'm holding off on the percentage because another code officer wants to testify on their behalf as well. For case CE 2004-0120, the property was cited July 18, 2020. The property was cited for clean and sanitary, paint, junk, abandoned vehicles, landscape maintenance, parking requirements, and outdoor storage. The property was given 30 days or $400 a day to achieve compliance. The property was out of compliance for 491 days, resulting in a lien amount of $196,400. Again, they are new owners, so it doesn't say it. Oh, did I say the wrong case number? Let me correct that. Yeah, case C. It's actually case CE 200-70301.
How long were these properties out of compliance? This property? How long was this out of compliance?
That one was out of compliance for 491 days.
Can you tell me your names, please?
Hi, how you doing? Nestor Martin, my wife, Isabel.
Martin.
Can we approach you with
You have to show it to the code officer first.
Oh, okay, sure. Go ahead. We're just trying to show you a bit of history since we acquired the property. We'll wait until you have the file.
Go ahead, sir.
Hi, Your Honor. Okay. If you see on the first two pages, we acquired the property on May of 2021, 2 years ago. The idea was, fix the property, take care of all the situations, and get it on. So if you see, the initial pictures, it was the condition on the property. After that, as soon as we had really legally positioned the property, we contacted all the officers. We worked together with Carlos Maldonado, with Richard Pasmino, which was the code officer at time, Thomas Moore, in order to bring it to compliance. On the first step, we tented the main house, we saw the whole property. We spent on the initial step about $20,000. And if you see, you'll see the pictures, how it came up. The code violation was not stopped at that moment, it continued. They let us know that since the building was caught on fire, they wanted the building demolished and rebuilt. So we didn't stop. On the other two pages, you're gonna find the third stage, which was the demolition. We went, through the whole process, all the meetings with the code officers and the whole permitting process. The demolition, it took us like about $30,000 to demolish the property. And then right after, we demolished the property, we commenced the reconstruction of the property. You're gonna see pictures, during the process. And the whole reconstruction, it took us like about $250,000 to rebuild the property. And on the final page, you're gonna see the final product. The two structures completely, renovated and rebuilt. And we have tried to resume this work in one page, but there's so much more effort in the project that is impossible to translate into words. Moreover, financially, up to the date, we have spent over $300,000 to cure any infractions and code violations on the property. Also on the final page, we attach a letter from our CPA accountant attesting our expenditures on 2021 and 2022. And at this point, we're a small family business, and we kindly ask the judge to make an exception and take into consideration the end product and our effort and hard work and financial investment in order to bring this property back to the, to the city standards. We respectfully ask the judge, Your Honor, to reduce the fine between $1,000 and $1,500.
What's the city's position? You said you had an officer that wanted to testify?
Yes, Code Officer Pasmino.
Officer Pasmino, the floor is yours.
Good afternoon, or good morning still. Richard Pasmino, City of West Palm Beach Code Enforcement. All my interactions with Mr. Martin, ever since he bought the property and took over, he requested we meet out there with Carlos, went over the violations at the property, the ongoing fines, told him what needs to be done. He took immediate, responsibility, ownership of the property, started working on everything. He understood that the fines couldn't be stopped until everything was fixed. As of today, he got great tenants in there. The property's been maintained since. It's a huge 360-degree turnaround of what it was. The old property had a fire. The old owners were never maintaining it. The tenants abandoned vehicles, trash in the front, nonstop. It was a big issue, and now it looks great, and they're maintaining it. Really responsive, really fast, and got everything done.
Thank you, Officer Pasmino.
Thank you.
Does the city have an offer on this?
Oh, I didn't hear their offer. Sorry.
If possible, we would like to have the fine reduced between $1,000 and $1,500.
Just a second. KC 140604080, the city will counter with 3,000. And for KCE 20070301, we'll counter with 2,000.
That seems pretty reasonable.
We'll take it.
An easy day for me today. All right, case CE 140604080, I'll reduce it to $3,000. How much time do you need?
15 days.
30 days. And CE 200700301, we'll reduce it to $2,000 payable within 30 days.
Thank you, Your Honor.
Ralph?
Thank you.
Here's a copy of your order.
Right here. Yeah.
Case number 33960 North Flagler Drive, number 204, CE 150700656.
Morning, Your Honor.
Good morning. Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. Case CE 150700656 was cited on July 24, 2015. The property was cited for failure to obtain a rental license and certificate of use. The property was out of compliance for 2,128 days, resulting in a lien amount of $212,800. These are the same owners that caused the violation. City is seeking 25%. For case CE 15070, oh, did I say 657 already? 657. Property was cited on July 24, 2015. Property was cited for failure to obtain a rental license and certificate of use. Property was given 30 days or $100 a day to achieve compliance. The property was out of compliance for 25 days, resulting in a lien amount of $2,500. Case CE 1701453 was cited on January 20, 2017 as a repeat violation for failure to obtain a rental license and certificate of use. The property was out of compliance for a consecutive 552 days at $10 a day. The lien amount is $5,520. Same owner that caused the violation. The city is seeking 25%.
Sir, can you tell me your name?
Sure. My name is Daniel Ohm, and I represent the owners.
I'm sorry, go ahead. Mr. Own?
Yes, Ohm, O-H-M.
Okay, go ahead, sir.
So the foreign owners, our position on this is the foreign owners were not aware until they tried to sell the property that these liens actually existed. They're selling the property, I've been trying to sell the properties due to failing health issues. They had a previous property manager that had basically told them that the BTRs were only needed on seasonal and short-term rentals, which was obviously not the case. In this file, to resolve this, there were 3 applications that were essentially done in this process. The first one was in 2020. That one expired due to the owners failing health, and it was difficult, them being in Argentina, to basically get into contact with them. Then, when that expired, as soon as that expired, we filed one in 2021. There was an issue with the inspector that had come out. He had left the position and didn't make any notation in the file, and subsequently that expired as well. And then the 2023 application is where we are here today. They want to resolve this issue so the owner can continue with the sale of the property and basically liquidate on the 2 properties. I do have an affidavit here from the property manager that they are currently holding $10,000 to basically fully resolve these liens and compromise. In light of all this, we ask for this reduced amount.
So this is 2 different properties. This is
It is 2 different properties, yes, sir.
3960 North Flagler Drive, and then 1801 North Flagler Drive. So these are apartments, I guess?
Yes.
Yeah, condos.
And then we're being, I guess the number 204 was out of compliance for 2,128 days. That's many years.
Yes, and it was due to very poor property management that they had in place because they do reside in Argentina. So they were actually not ever made aware by the previous property manager. Since that time, they've switched, obviously, property managers.
And so you're asking me for $10,000 for both properties?
Yes, sir.
And the city offered what, 25%?
Mm-hmm.
Do some math here. So the city's offering to reduce it to $53,200 on the first property, and
$625 on number 4 and $1,380 on number 5.
how much number 5?
$1,380.
So that puts you guys about $45,000 apart. I will tell you, I generally tend to be a little more forgiving when it's a short period of time, and I also tend to be a little more forgiving when it's a different owner. But in your particular case, even under the code requirements,
Because everything was basically being directed to the property manager, so the owners were actually never aware until they actually went to go sell the property and these liens popped up. You know, the property manager, you know, did a number on them, unfortunately. And now, because of the owners failing help, they just want to basically sell the properties and continue and hoping to basically, you know, have these reduced.
well, I can't do 10, but I'll go lower than the city's asking, but you got to make me a better offer. I mean, I can give you credit for hardship under the code D8.
Can we do 15?
What's the city's position on that?
I just want to point out that this is a repeat violation with the unit 1801 North Flagler Drive, unit 403. So we have to take that into consideration. That notice was sent as well several times, regardless of failure of the property management. That's not really, you know, the city's position, but we're willing to counter with 25.
Would we be able to meet in the middle at 20?
City says yes.
What's the middle?
City said yes on the 20.
All right. So why don't we do it like this? We'll do 18 on case number 3, and we'll do 1,000 each on case 4 and 5. How much time do you need?
15 days.
I'll give you 30 just in case. So 18 on case 3, and 1,000 on 4, and 1,000 on 5.
Thank you so much.
Yep.
Have a great day.
Number 7, 316 Southern Boulevard, CE 200100506.
Good morning, Your Honor.
Good morning. Is it still morning? Yeah, still morning. been a long one.
Just a second. Sorry. All right. Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. Case CE 200-10506 was cited on January 28, 2020. The property was cited for failure to obtain a certificate of use and a business tax receipt. The property was given 30 days or $150 a day for compliance. The property was out of compliance for 369 days, resulting in a lien amount of $53,350. Special Magistrate, the applicant was the same as was the violator. The city is seeking 25%.
So this company was founded by two individuals in late 2019.
Can you tell me your name first?
Yes, Kevin Gagnon. I'm the Chief Financial Officer for the company.
Of 316 Southern Code.
That's the entity for that one particular car wash. We've got two other car washes that have different addresses, and we identify the company name by the address. So this was a car wash on 316 Southern.
In your position with that company?
I'm Chief Financial Officer.
The Chief Financial, CFO?
Yes, been there.
And your name was again one more time?
Kevin Gagnon.
Kevin Gagnon?
Gagnon, Gagnon. So I've come on board since last August. But these two founders bought the company in late 2019. This car wash just hired a bookkeeper. So just three individuals trying to get a company going. COVID hit 2 months later. And the last time, there was communication was the end of February, and COVID obviously became apparent in March. And for the next year, until the next communication, which was a phone call around March of 2021, there was really no other communication, so the owners forgot about it. And again, three individuals trying to get this company going during COVID. As soon as they got communicated a year later, they rectified it immediately. And we didn't just become...
Were they not getting the notices from the city?
The traffic flow that I see right here, it was probably going to a trailer. That's where their office was, out of a trailer on this property. So, they weren't organized. They had a bookkeeper they had just hired. And so during COVID, like I said, they, trying to man through, what was happening. They couldn't address the issue, but when they finally got another notification reminder, they did pay it. We just became aware of it last December when we were trying to refinance one of our loans, and the lien came up. And so I do want to note that this company is a growing company in Palm Beach County, that we're adding car washes across the county. We do a lot for the community, where we adopt parks and beaches to do cleanup, every other week. And so we're just looking, because of that COVID year and these founders just getting this company going, they just were lax in getting the paperwork processed.
How long was this out of compliance?
I was out of compliance for 369 days.
How many?
369 days.
So about a year?
Yeah, about a year.
And it was that February where they got notified, and then COVID hit, and then the next time they actually got a call or notified again, it was like a year later.
Well, yeah, so it was hand-delivered to the business by Code Officer Pasmino, and he spoke with the manager at the time. And then he states here again, even after the magistrate's order on March 11, 2021, he emailed and spoke to the management at Mint Eco Car Wash, provided a new business license application and instruction on applying, and also informed them that flag banners and snipe signs needs to be removed. So, he did stay in communication with the property, so if they needed any leeway or prior to the going to hearing, he would have provided it, because it's...
Yeah, do you know,
I understand that COVID did, he is correct, COVID did, we can, take that as well, but he was in constant communication with the property management, letting them know that they need to fill out a business tax receipt, and that really didn't take much, especially in the place of COVID where, it was just paperwork, honestly, that needed to be
Do you happen
filled.
to have names? Because the two founders, when I approached them about this, they don't remember getting communicated from, and so it may have been the manager that's on the site.
Well, regardless if they, whoever stated that they didn't remember speaking with him. It was hand-delivered, and we also sent it via USPS, where it was signed for as well, too. So we did achieve notice many different ways.
Well, it sounds like somebody dropped the ball, but the city's offered to reduce it from $55,350, if I did my math right, to $13,837.50. But what are you asking me for?
I mean, COVID impacted all of us. And
It did.
And it's like it's that year between, of COVID, because it was February, March of 20 to really, March of 21 when vaccines started. I mean, there was a lot going on that year. And
I know, I was here.
Yeah, I know. I think we all experienced it. I originally, had put in $1,250, $3,000.
Well, you came in here with a $55,000 lien.
Yeah, I like I said, I can't dispute that.
I'll tell you what I'll do. I'll reduce it to 6. How much time do you need?
2 weeks.
30 days.
Sir, here's a copy of your order. Sir, go get your order.
What's that?
Your order from Ms. Erica. Put a sign up or something. Number 8706 Executive Center Drive, number 36, CE 170105561.
Okay, you have to say it in what you're giving. Yeah, no problem. Cassandra San-Hilaire, Code Enforcement Officer with the City of West Palm Beach. Case CE 17010561 was cited on January 25th, 2017. Property was cited for failure to obtain a rental license and certificate of use. The property was given 30 days or $100 a day to achieve compliance. The property was out of compliance for 2,095 days, resulting in a lien amount of $209,500. The applicant is the violator. The city is seeking 25%.
Ma'am, can you tell me your name, please?
My name is Carolyn Crichton. I'm an attorney for Jamie Grady, who's now known as Jamie Smith. I'm going to refer to her as Jamie. She's the owner of the properties. If I may approach, Your Honor.
Can you tell me your last name again one more time?
Crichton, Crichton.
Okay.
May I approach? I have a couple of exhibits. That's what I was trying to offer to Cassandra.
Is this what you emailed us?
It's part of it.
Okay.
I tried to reduce it down and also for Your Honor, more concise.
Okay.
Your Honor, we're requesting a reduction to 0 due to the due process violations with regard to this case. Jamie was cited, as Cassandra said, in January of 2017. There was a notice that was mailed to Jamie at the address that the property appraiser had, and that address is owned by Jamie's husband. There's a card for it at the very back of the pages for the 2 West Yale Street. And that mailing was sent in an envelope that was dated January 26th, and it was returned undeliverable. The city code allows posting at a property if, when it is mailed, it is returned as unclaimed or refused. But in this case, the mailing was not unclaimed or refused. It was returned by the post office marked undeliverable. So the city at that point had knowledge that Jamie did not receive that notice. They did post at the property, which has some irony to it because she's being accused of not having a rental license, and so they obviously know she doesn't live there. She's renting it to a third person. But Jamie had no notice at all. The hearing occurred in April. Jamie didn't participate because she didn't know it was happening. And at that time, the hearing officer enters the order that cites her with the violation and gives her 30 days. That order was mailed only to the property. And you'll see with the copy of the envelope that's included, and all of these documents, Your Honor, were obtained from the Code Enforcement Office. And we're assuming that the envelopes correlate to what was being mailed to her. We don't actually know what was in the envelopes. But there was another mailing to the property address in May. Jamie similarly never received that. But Your Honor, then we come to the crux of the due process violation. And that is the violation of the case of Massey versus Charlotte County. It's a case that was decided in 2003. The citation is 842 Southern 2nd 142, and you have a copy of the case. And this situation that we have here today is on all fours with the Massey case, Your Honor, in which the violation, the order was found unenforceable. What happened was, unbeknownst to Jamie, on May 9th, slightly more than 30 days after the first hearing, a code enforcement officer signed an affidavit of noncompliance. There's a copy of the affidavit in the packet that I gave you, and that affidavit of noncompliance has absolutely no evidence that the city made any attempt to send it to Jamie. That is the same situation in the case with Massey, where the Charlotte board had an affidavit from a code enforcement officer, and they did not send it to the property owners. Subsequent to that, with no notice to anyone, a special master considered the affidavit, and on the basis of the affidavit, entered the order imposing the $100 a day fine. There was no notice to Jamie. She had no opportunity to confront the allegations that were in the affidavit, and she really had no notice of any of these proceedings or an opportunity to cure it. Now, ignorance of the law isn't a defense, we admit that, but she truly didn't know she was supposed to have a license. And the city never got her notice, and the city had actual knowledge that she wasn't getting notice. They knew that all the notices they sent were returned undeliverable. They weren't rejected, they weren't unclaimed at the property, they were returned undeliverable. And then the city intentionally used a procedure which the Massey court has found to be a violation, an intentional violation of due process rights, when a special master enters an order imposing a fine and a lien on a property based solely on an affidavit in which the property owner has never been given the affidavit itself or notice that it's going to be considered or an opportunity to come in and oppose the affidavit. Your Honor, even in summary judgment proceedings, civil proceedings, where a judge decides on the basis of affidavits, the opposing side is given notice of the proceeding and is given an opportunity to submit its own affidavits. And in every other proceeding, the accused is given the opportunity to contest or cross-examine the person who's making the allegations. And in this case, Jamie was never given notice of that affidavit, was never given notice of the subsequent proceeding in which that affidavit was relied. And the Massey case found squarely that that is a violation of due process. And so for that reason, Your Honor, and because of the due process violation here, when Jamie found out, the way that she found out was in January of 2022, she entered into a contract to sell the properties. In May of 2022, the title company that was handling the closing ran the title report, and that's when Jamie got notice that any of this had happened a year ago. She acted immediately. She got us involved. We conducted the investigation. Most of the delay between late May of 2022 and July 11th, when her application for the rental permit and the certificate of use was submitted, most of the delay was our back and forth with the code enforcement and getting copies of her file. She acted promptly to remedy the situation.
Let me ask you.
Yes.
Is a fine reduction hearing the appropriate venue for these allegations?
Well, Your Honor, the other venue is that we sue the city on the enforceability. And so the route that we're taking, I've been in conversations with the city legal department and suggested that we go this way first. But it's a clear violation that a court has considered.
It seems like what you're suggesting that I do is that I rule that the city's procedure is in violation of either the due process requirements of the Florida Constitution or the due process requirements under Florida law. I'm not sure I have the authority to do that.
Well, the Massey Court's already done that for you. It's clearly on all fours.
Well, I'm going to guess that the city doesn't think so. And then you're asking me to make a ruling of law, interpret law. I'm not sure I have the jurisdiction to do so. I mean, I don't know. What's the city's attorney's position on this?
To keep it clean, I don't know if Attorney Crichton has additional argument to offer before it switches to me.
Sorry, I didn't.
I'm just trying to keep it clean.
Why don't you finish presenting whatever else you want me to know, and then we'll...
Your Honor, the additional arguments are that as soon as she found out about the violation, she acted to remedy it. There have been no other code violations on it. She has 3 properties. She's never had a code violation on any of the properties. She has been fined, so to speak. Not only has she incurred attorney's fees remedying this, she lost the sale, primarily because of the length of time it took from the time that the application for the certificate of use and the rental application, and then also the lien reduction application to this day. She's lost the sale. So she's been fined. She's been hurt by this, and now she has damages.
Okay. Let me hear from the city.
For housekeeping, Attorney Crichton submitted a composite of exhibits. City has no objection. They're just copies of City's Code Section 2636, copies of the documents in this particular code case file, a copy of Massey v. Charlotte that the attorney makes note of. I'm not sure what the relevance is of the property record in Orange County for the Yale Street address, but
that was just to show that they originally mailed it to a property that they actually own. We don't know why it came back, but it came back. It's too bad that it wasn't attempted again. Instead, they mailed, the only other mailing subsequent was to the property address, which the city knew she didn't live at because that was the violation. She's renting to third party.
Thank you. So I think you had given the special magistrate a copy of his own. Okay, so this is for you if you'd like it.
I'm sorry, go ahead.
Okay. So just kind of going back to notice, I know that Attorney Crichton highlighted the codes, the city's code 2636A, but also B indicates in addition to providing notice as set forth, notice may also be served by publication or posting. The posting was done. C, notice by publication or posting may run concurrently with or may follow an attempt or attempts to provide notice. So not only did, excuse me, I'm so sorry, the city, the city's argument is that not only was the notice of the service of the notice of violation appropriate per its own section 2636, but also pursuant to the statute for notice as well. The regular mail didn't come back. You know, anybody can unclaim or let a certified mailing sit. And the city did at that time use the address that was listed in the property appraiser's database as pursuant to what we see on PAPA for the website. There was a printout contemporaneously done of that PAPA website at the time of the notice of violation showing that the proper address was used. So they had an opportunity to be heard. Proper notice was found at that hearing. Evidence was given, taken, and set down in an order. Those orders are not required to be mailed by certified. It was mailed by regular. In addition, it's very clear in the statute, it's very clear in the city codes, which I do believe that people have to take notice of and are on notice of, that they do have appellate rights, that there has been, a hearing provided before they're being deprived of anything. In addition, once that affidavit is done and the lien is signed, that is sent as well by regular mail. So the fact that, and I'm not sure I heard correctly, but the fact that Ms. Smith or Ms. Grady was not in that particular property to receive the posting of the property, I don't think that's necessarily relevant. It's, the city did what it needed to do by statute. As well, the city provides a lien reduction hearing for just this reason. The city is very reasonable in its lien reductions, and understands that, everybody's been entitled to the process. Everybody's entitled to have their voice heard, to receive a lien reduction. Let me just look at my notes. I apologize.
So it seems to me that there's, if I understand this correctly,
Yeah.
two arguments that you're making,
Mm-hmm.
right? The first is you're arguing that notice under 2636 was not accomplished according to the requirements of the code.
That's correct, Your Honor.
Right? And the second argument you're making is that even if that were true, the procedure was improper.
And Your Honor, that really is the crux of the argument, because there are arguments as to whether or not there was proper notice. Putting that aside, there is no question that on all fours with the Massey case, the affidavit that was relied on by the code enforcement officer when the order imposing the lien and the fine was entered was not ever sent in any fashion to Jamie. She was given no notice in any fashion, not by posting, not by mailing, in no fashion of the May hearing in which that occurred. She had no opportunity. In fact, Your Honor, in the Massey case, the Masseys, the property owners, they did have notice of the fact that this proceeding was going on, and they participated in the first part of the process. But where the court centered on was the fact that even though they were engaged and they had notice of these proceedings, then the Code Enforcement Board accepted this affidavit without sending it to them and without giving them an opportunity to come in and contest, the very heart of what our system of justice depends on. And the Code Enforcement Board in Massey relied on that and entered the order, and the court overturned it as unenforceable. So it was that's the part of the proceeding, and that's why we've asked for 0. Now, having said that, Your Honor, no, I did the calculation. I wrote down what she said, 209. If we did it through today, it would be 219,000. I'll take your 209. But I've never been offered a compromise, and I've been engaged with the code enforcement folks for a year now, and we've never heard anything about a compromise.
They are currently in compliance, right?
Yes, they have to be to get here.
Yeah.
What was the compliance date?
January 30th, 2023.
And that's when the fine stopped running.
That's when the fine stopped
So that's
running.
how you calculated 209?
Mm-hmm. That's when we notified them that they still needed a rental license because the property was still being rented out.
But, Your Honor, the application that she filed for these licenses was filed July 11th, and we actively pursued it all of that time. It was not Jamie's delay.
Why did it take so long from between July and January?
It took forever to get it inspected. And I think
Do we
it
know
got
why that is?
inspected 3 times. We finally, when the police officers took over doing the inspections, Officer Gellin is the one that I dealt with, and he was awesome. and got it done within a week, but it had been months. And I was calling and emailing regularly.
Can I comment on that?
Yeah,
So
go ahead.
this is really what happened. As we're processing the application for a lien reduction, which does take up to 90 days, and everybody in here will tell you that. While we're processing it, I looked through and I noticed that they still did not have a rental license or a certificate of use, so we could not move forward with their application because the fines were still accruing. At that time, the officer that was assigned to that zone had actually left the city of West Palm Beach.
and
So
just
they
left
were
it.
contacting that code officer. So they stated they were contacted them until I sent Ms. Crichton an email, hey, you know, you guys still don't have the proper licensing. Until we get this, we're not able to move forward. It was then because Sergeant Gellin, he is the supervisor for that area. He did get with Code Officer Don Williams, to do the inspections. The tenants were not available at the time, and one of them had believed that they had contacted COVID. So that was the delay in us going out to finally do the rental inspection. It's not a refusal. It wasn't because we were taking our time with it. There was delays per tenant issues, but the moment we processed it for lien reduction, we notified Ms. Crichton what was needed to move forward.
Your Honor, I can also tell you some of the confusion comes with the process in that when we filed the application, and I did it personally, when we filed the application for all 3 units, you get back receipts saying you've paid all of the fees that are involved. There's an inspection fee, and then there's just the regular fee for it. And then there was no further paperwork. There was no indication sent to me that there was anything, and I had all the receipts. So then we submitted our lien reduction package. And it was only months later that the ladies came back to me and said, oh, you still don't have your license. Well, I had no way of knowing that the receipts that I had that says you paid for this license weren't sufficient. And so then at that point, that's when we discovered that the person that was supposed to be doing the inspections, as Cassandra said, had actually left or been fired, depending on who you spoke to, and he'd never conducted any of the inspections. It just, I think, sat on his desk.
Special Magistrate, please note that...
But once Sergeant Gellin got a hold of it,
I was the one that gave it to him, but please note that when you come and file, whether it's a business tax or rental license, and you pay for it, the initial fee, on the receipt, it does tell you this does not mean that you have a rental license. You need to contact this code officer to make an appointment with them.
And I agree with her, the email does say that, and I did make contact that day with that person, and then that's the person who let it sit for months. And I had no idea that
All right, I'll take into account that clearly there were some communication struggles here. The city offered to reduce it from 209 to what?
Number 9, right? I'm sorry, 25%, 25%, 52,375.
You want to make me an offer, or do we want to do it I mean, we can try and resolve it here, or I can try and figure out the law. One or the other, or we could do both.
How about $2,000? Jamie is out. She's lost the sale of these properties now that having gone through this delay. She would have remedied it immediately had she gotten any of the notices, particularly if she'd gotten the affidavit and known they were going to enter an order against her. But that clearly the city fell down on.
I mean, the second argument's interesting to me. I actually think that's an interesting argument. The first argument's a little less persuasive to me because, I mean, every day that I do this, there's somebody that says I didn't read, it was mailed to an address. As long as it was mailed to the property appraiser's address, to the address in the property appraiser's record, and the city followed the requirements under Part B of 2636. The fact that they didn't get actual, it literally says here, actual notice is not required. So I don't find that persuasive. The second one's interesting. I don't know. Maybe I could look at that, but I don't know. So the city's at 52 and you're at 2. That's pretty far.
Yeah.
I just want to make one point that I'm hearing. if we did say we did mail out a affidavit of noncompliance, we'd still be sending it to the address that they gave to the property appraiser, and they'd still not be receiving it.
No,
It's just
I don't want to spend any longer
Yeah.
arguing about the notice question, because I don't think it's going to be resolved here. I think I'm not persuaded by the first argument. I'm not sure about the second one, but I'd have to do some research and probably let the city brief it. But if we can reach a number today, maybe it becomes moot. I don't know how to get you from 52 to 2, though. It's pretty far.
So, Special Magistrate, after convening with City Attorney Frank Canaro, we will accept the $2,000 offer.
Done.
Damn. And I was going to do the research. All right. How long do you need?
30.
Done.
Thank you.
Case number 9, 615 56th Street, CE 211-00200.
Code Officer Cassandra St. Hilaire with the City of West Palm Beach. Case CE 211-00200 was cited on October 15, 2021. The property was cited for failure to obtain a certificate of use, a garbage can placement, failure to obtain a rental license, business tax receipt, landscape maintenance, parking requirements, and outdoor storage. The property was given 60 days or $100 a day to achieve compliance. The property was out of compliance for 205 days, resulting in a lien amount of $20,500. The applicant is the violator. The city is seeking 25%.
Please tell me your names, please.
Good morning, everyone.
So your name is?
My name is Ricardo Grant. This is my daughter.
Carnino Grant.
Ricardo Brand?
Yes, Ricardo Grant.
Grant?
Yes.
Oh, Grant.
G-R-A-N-T.
You're the owner of the property, sir?
Yes, sir.
So the city says there's a $20,000, $500 lien. So what are you asking me for, and why should I grant it to you?
I'm looking at asking for $1,000. So, simple. The reason is because I lived in West Palm, but I worked in the U.S. Virgin Islands, and letters come to the house, and my wife and my daughter doesn't open it up, and that's not an excuse. We're here to begin with. Regarding my tenant is not one of the best person to work with. He has the outdoor storage. I have that removed. The parking, I discussed this with him.
Well, I'm going to presume you're in compliance, otherwise you wouldn't be here. So I'm going to guess that everything is good. So the fine is $20,500. What are you asking me for?
I'm asking for $1,000, sir.
How much?
1,000.
What was the city's offer here?
25% is $5,125.
Tell you what I'll do. You're going to maintain. You're going to keep this property maintained, right? We're not going to let any more tenants do.
It's a beautiful property. When I first took it over 4 years ago, it was a mess with drug paraphernalia, prostitute. Everybody goes in there, and it was taken care of ever since. I put a lot into
I'll reduce it to 10%, which is $2,000. But I don't want to see you come back on this. All right?
The we was dealing with, they are Spanish. We try to work with them, and then they're no longer there. So the tenant that we're dealing with now have worked with us, and I've gone and checked. I live in
that sounds good. How much time do you need?
60 days, sir.
All right, $2,000 payable within 60 days.
Thank you.
Have a good one.
Okay. And lastly, numbers 10 and 11 for 480 Executive Center Drive 3N, CE 2103047 and CE 1909070.
Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. KCE 21030047 was cited on March 3rd, 2021. The property was citing for plumbing fixtures, clean and sanitary, failure to obtain a rental license, and certificate of use. The property was given 30 days or $500. The property was out of compliance for 576 days, resulting in a lien amount of $288,000. For case CE 19090170, property was cited on January 11, 2012. Property was cited for failure to obtain a rental license and certificate of use. This was a repeat case. The property was out of compliance for a consecutive 28 days at $150 a day. The lien amount was $10,600. The applicant is the same as the violator. The city is seeking 25%.
Sir, can you tell me your name, please?
Yeah, my name's Kevin Smoke. I'm the attorney for the owners of this property.
I'm sorry, your last name, sir?
Smoke, SZMUC.
Small?
Smoke.
Small.
Smoke.
I'm just
That's fine.
All right, so tell me what you're asking me for and why I should grant it to you.
Okay. For the first lien, we're asking for a reduction of $1,000. And the reason being is that my clients purchased a property in 2019. They believe that that somebody else handled that issue. They were not aware. I know that's not an excuse.
Not a good one.
Not a good one, I understand, but they really do not know where that lien came from. They closed on the property, and they don't know if it was the title company or somebody else handling that issue on their behalf, but they had no knowledge. As for the second lien, the one in 2021, my understanding is that it was a disgruntled tenant. They were having issues with the tenant for non-payment and whatnot. So the tenant reported them to the city. The city came out, cited them. Now, you got to understand, the owners do not live in the United States. They live in Argentina. But they did comply. The problem is that, being foreigners, they did not know that they had to report back to the city. I did submit with my application some statements that they of them fixing the property after, I believe it was around June. So they missed the compliance, but they did go in there and they made a few repairs, and then I believe the $500 a day on the second lien was imposed in October. So at the time that was imposed, they had already complied. Problem is that they never
The second one is not fixing anything. It looks like it's just the absence of a rental license.
Yeah, Special Magistrate, I just want to make a correction for the second one. I apologize. So the case number is CE 1909070. It was not a repeat violation. It was actually out of compliance for 53 days at $200 a day. That resulted in the lien amount of $10,600.
And this was for absence of a rental license and certificate of use?
Yep.
And
so the first one also has a certificate of use issue. Was that a difference?
So renewal, that one was for renewal.
Okay.
Yeah, but also let's really understand what he's saying. But regardless if it was a disgruntled tenant, when the code officer went there, they did find evidence of there being mold and mildew in the unit. So that is something that is a health and safety.
We're not disputing that.
Okay.
What we're saying is that they did comply timely. The problem is that then them being foreigners, they didn't report compliance, even though they had compliance. And I believe I submitted some scope of work, some photographs from that time when they complied. The problem is that they never notified the city. But they had complied at that time. They also, I believe, had an issue with the property manager they had at the time.
You guys are losing me. So you're talking about the first case?
Second.
The second case. So the second case is the $10,600 about.
I believe that's the first, the 10,000.
So and your argument there is that they complied sooner than the city noticed that they complied.
No, that's for I'm sorry, that's for the 2021, that's the argument, that they complied, but they didn't notify the city.
We kind of have them a little, so case 11 would be the 2019 case, and case number 10 is the 2021 case. Yeah, no, it's fine. I just want to make sure he's on the same page as us. So,
All right, so let's stay with case 10 just for
Okay.
a second, because that's the larger amount here, right? That's 288,000. So what's your argument for reducing, if I wrote this down correctly, you've asked me to reduce this from 288,000 to $1,000. So what is your argument for reducing that to that?
Oh, for that one, I was saying 1,000 for the other one, so
Okay.
I do apologize.
All right, so what are you offering for the first one?
For the first one, we're offering 2,500.
All right, what is your argument for why I should reduce it from 288 to 2,500?
The violation, I believe, is from April 7th. By June 21st, they had already done the scope of work and repaired. I do have a receipt. I can provide it, which was submitted with the application.
If you have it, you can show it to the code officer.
Okay. I believe I sent it with the application, but...
Well, I don't have it.
This is what it was done on the property.
So the city must have record of when they came into compliance by getting their rental license and certificate of use for case number 10, right?
Yeah, the compliance date is December 7, 2022. So the invoice that he's provided showed that they did hire somebody to maybe do the work, but if we're not contacted, we do not come back in the unit to get our own pictures and ensure that all that's been cleaned up. How can we, we can't certify that. But alas, let's not negate the fact that even with doing one part of the notice of violation, the rest still exists. So the property was cited in March of 2021, compliance wasn't met till December 7th of 2022. That's when the code officer, based on their investigation, that's when the property came in compliance. That's when they were either notified or was given access back into the unit to see that this work was done.
So, I mean, just so I understand, so your argument is that the plumbing and the mold and mildew issue was addressed by Cleary Plumbing in June?
Yeah, that's my understanding from what.
So, but the other thing required is that you needed a rental license and a certificate of use. When was that done?
I can call my client and ask them, but I believe now it's up to date.
But that
I was not aware that the issue was a rental license, to be frank with you. I thought the issue was the mold itself.
Well, if I read this correctly, there's 4 code sections that they were found in violation of: plumbing, mildew, rental license, and certificate of use. Presumably, they must have gotten those at some point, right? Otherwise, they wouldn't have been complied.
Nope. Yeah, they got it in December 7, 2022.
So that's when they got, so that's why. So even if I were to accept that you fixed the mold and the plumbing in June, I couldn't even take that into account in reducing it because your client didn't do the other stuff until December. That's only 2 of the 4. You don't get partial credit. What was the city's office was 25%? What's 25% in the 288?
72,000. I also want to note, I apologize, I just noticed this too. The code office, there was a permit put in, and okay, maybe I'm okay, I apologize. I'm misreading it. That was the lien reduction application. But yeah, so 25% is $72,000. Yeah, sorry about that.
So I'd say we're pretty far off here. Even if I cut it to 10%, you're still at 28.8. I can't, based on the testimony that I've heard, I can't reduce it to 2,500, but make me a better offer.
Can you do it, can you do 7,500?
Tell you what I'll do, I'll reduce it to 10.
And what about the case
One
number
case at a
11?
time. How long do you need?
Can we do well, we can pay in 30 days, but can we do 10 on both cases? Is that a possibility?
Total 10.
Total 10.
Oh.
Yeah.
What's the city think about that?
I'm fine. Yeah, we don't oppose. We'll just go with 9,000 for,
All right, we'll do 9,000 on 10 and 1,000 on 11.
yeah.
Thank you.
30 days payable in both cases. You want your receipt back?
Sure, whatever.
Sounds good. That's it, right? See no further business before us. This meeting is hereby adjourned.